Yes,
May I please, Your Lordship. My Lord, I beg to mention item number 21.
21.
Yes, my Lord. I'm not pressing this petition, my Lord.
At the request of Mr. 21,
21.
J. Abedin, learned counsel for the petitioner. On instructions, the writ petition stands dismissed as not pressed. Interim order, if any, stands vacated. Finance, so and so appears. Education, health, Dipora. Yes.
Deeply obliged.
May it please, Your Lord. My lord, I am mentioning a serious matter pertaining to regularization, my lord. And this matter, my lord, of 2019, my lord, and is covered by similar writ appeal, my lord, referred by one of the writ petition, my lord.
Yes.
So I pray, my lord, Lordship may take it up for hearing on any date in March. It's a covered by division bench. I have a copy, my lord. And any date, my lord, on March 2nd week, my lord.
Let it be on 1st of March.
Yes, ma'am. 1st of March.
Oh, sorry, not 1st. 5th of March.
5th of March. I am obliged, ma'am.
Lordship, I beg to mention item 34.
34.
Kindly adjourn the matter for the day, and this matter may be fixed.
We can fix it, it will be adjourned.
No, Lordship, similar matter fixed on 6th, Lordship, along with WPC number 4983.
At the request of Mr. A.Z. Ahmed, matter stands adjourned to 6th of March. To be
Yes.
listed along with
WPC number 4983 of the 2020.
4983.
Yes.
Yes, of 2023.
23.
Okay.
May I please, Your Lordship? Lordship, I have filed a writ petition on 21 to Lordship. That may be come up for motion on 26 to Lordship.
It will come up ordinarily. Why are you making a mention?
Lordship, there is some urgency, Lordship, matter regarding suspension of a headmaster.
Suspension 26. No, it will be on. Let it be on 28. 28.
May I please, Your Lordship, I would like to withdraw item number 22, Your Lordship.
22.
Lordship. The parties filed succession case, Lordship, that succession order was passed. So the parties want to withdraw.
Okay. As submitted by Mr. A.R. Som, learned counsel for the petitioner, on instructions that the writ petitioner does not wish to press the petition any further. Accordingly, the same stands dismissed on withdrawal. Interim order, if any, stands vacated.
Obliged, Your Lordship.
Mr. Finance, you're there.
My
Mr.
lord.
Gaur Pujari for finance, and who's there for accountant general? Mr. Talukdar for accountant general. Okay.
May I please, Your Lordship? Lordship, item number 44, my lord, I may be permitted to withdraw with liberty to approach the appropriate authority.
Item 44, learned counsel for the petitioner, Mr.
H.K. Sharma.
H.K. Sharma seeks liberty of the court to withdraw the matter to approach the appropriate authority.
My lord.
Liberty is prayed for, is granted, writ petition dismissed on withdrawal, interim order, if any, stands vacated.
Much obliged.
MSL Devi for CGC appearing as for the
May
respondent.
I
Yes.
please, Lordship? Lordship, I beg to mention for listing one WBC, Lordship. Lordship, matter pertains to transfer, Lordship. Lordship, in
Transfer?
last week of March, Lordship, many days.
All right, 2nd of March.
Much obliged, Lordship.
May I please, Lord? Lordship, I beg to mention listing of the case, Lordship, in Muswami's case, Lordship.
2nd of March.
Lordship, the petitioner is going to be retired on 29, Lordship. So, Lordship, any
29th of?
matter pertaining to suspension has yet to be reviewed by the authority, Lordship.
When was it filed? Writ petition.
Lordship, earlier it was listed before this Honorable High Court, Lordship. On
When?
29/1/2024, and Honorable Court has fixed the date but wrongly put on record, Lordship. For which, Lordship? So before 29, any date, your Lordship.
Before 29.
Otherwise, Lordship, will
He is retiring.
yes, Lordship. Going to be retired on 29th of February, Lordship.
28.
Highly obliged.
May I please, Your Lordship? Lordship, I would beg to mention item number 39, my lord. My lord, in this matter, seeking adjournment for today, my lord. As we be filing
Item
additional-
39 at the request of learned counsel, matters stands adjourned for 2 weeks.
Deeply obliged.
May I please, Your Lordship, prayer for listing. The matter pertains to non-payment of family pension.
Non-payment for family pension. Let it be on 4th of March.
Obliged.
Yeah, please, Your Lordship. Item number 32 and 33. I took
Item number
32 and 33.
32 and 33.
33. It's not for adjournment, Your Lord, for 2 weeks.
Item 32 and 33 adjourned for 2 weeks along on the request made by Mr.
As they,
S. Day for the respondent.
for the response number 6.
Have you taken consent of the petitioner?
Yeah, already I have.
It is submitted that consent of the writ petitioner has also been obtained.
Much obliged.
Yes.
May I please Lordship? Lordship, I take to mention item number 36. Kindly adjourn the matter for 3 weeks.
36.
Yes, Lordship.
You are making a mention on whose behalf?
NK Muri.
Item 36 at the request of the learned counsel for petitioner, matter stands adjourned for 4 weeks.
Please. The matter has become infractuous.
It is submitted by Mr. Bora, learned counsel to the petitioner, that writ petition has become infractuous. It seeks liberty to withdraw the same. Writ petition accordingly dismissed as not pressed. Interim orders, if any, stands vacated. Mr. U.K. Goswami appears for the respondents. Pending IAs are also dismissed.
Your Lordship, I may be permitted to withdraw the item number 2 only, Lordship, with a liberty to file in phase 1. And subsequent development, Lordship.
Item 2,
Item 2 only.
at the request of Mr. H. Bezbura, matter stands dismissed on the submission of Mr. H. Bezbura. Matter is dismissed on withdrawal. As it is submitted, the subsequent developments are required to be brought on record. He therefore seeks liberty. Writ petition dismissed with liberty. Interim orders, if any, stands vacated. Item 3 to be listed separately
Lordship.
for admission.
Lordship. Much obliged.
May I please, Your Lordship?
Hmm.
Lordship, the petitioner is the deputy inspector of school. He was under suspension, my lord. He was suspended as he was arrested in a case, ACB PS case number 10 of 23, Your Honor. Thereafter,
No review. Any instructions?
No, my lord.
Get your instructions heard, learned counsel for the
on the
purpose.
last- my lord,
Let him get instructions.
on the last occasion, my lord, they were taken time actually. For
On the
instruction, my
last occasion, last order reflects that counsel for petitioner prays for an adjournment on 3-1. So let him get instruction.
My lord, previous to that order, one order is there also. my lord.
That's right, but
First
it is
First order, my lord.
more than 1 month. Let him get his instructions. Heard learned counsel for parties, Mr. N.J. Khatwania, learned standing counsel elementary.
Elementary, my lord.
We will obtain instructions with regard to the matter. Although notices are not issued at this stage, extra copies be furnished to the standing counsel within 1 week from today.
My lord.
Matter be listed after 2 weeks. Yes,
Lordship, in this case, Lordship, we have received both the hubs of the PPO from the concerned treasury officer. Will be able to issue within a week's time. So Lordship may fix the matter on next Friday, Lordship.
yes.
Next Friday.
Mr. B. Chakraborty, learned CGC submits that the matter is under active consideration and likely to be resolved within a period of
Weeks.
1 week. Within the next few working days, MSU Nanda does not object to the submissions made. Accordingly, matter be listed on 1st of February, 1st of March.
Much obliged.
Yes.
Supposed to produce the instruction, the transfer, the petitioner seeking transfer My lord, her
But,
first,
but the transfer is rejected.
my lord, first application was rejected, my lord, due
Uh,
to lack of proper documents. Second time, she again applied, my lord, online, and that is under consideration, my lord.
or under consideration.
Yes, my lord, the second application is under consideration.
Then
Since 2018, she is seeking transfer prior to that imposition of ban. There is the order also passed by this honorable court. So
we can
she
record
is
this
facing
submission
great
and
trouble due to the staff.
we can record this submission and dispose it off, or we can post
lord,
it
my lord.
after 1 week. What do you want?
After 1 week, so that.
After 1 week?
For 2 weeks, my lord, maybe.
After 2 weeks.
2 weeks. This is
After
the
two-
instruction, my lord, my lord, can have a look, my lord.
Heard Mr. U.K. Goswami, learned counsel for the
Probably, sir.
petitioner, and
Honorable থাকলে হয়ে যাবে।
Mr. N.J. Khatonier, learned standing counsel, elementary education. The the learned standing counsel submits that the prayer for transfer of the writ petitioner is under active consideration by the department. He submits that the matter be deferred for 2 weeks, by which time the department is likely to pass an effective order. Mr. Goswami does not object to the prayer made. Accordingly, the matter be listed after 2 weeks on 18 March.
অবলাজ বলছি।
Holiday nahi, March to no.
18 March.
Hello.
Yes, what happened? Any order passed?
Lordship, on behalf of the Managing Director of Textbook Corporation, we have a set of instructions.
You read it to us, tell us what is it?
Lordship, most of the formalities are complete. It is in final state. In principle, approval of the parent department is also there. The only thing that remains is transferring the fund to the corpus. So that's under process right now.
How long are you likely to take?
Lordship, there is no time frame indicated here as per our instruction.
Lordship may kindly dispose of this case, Lordship, by giving them in a time-bound manner, Lordship, to expedite the process.
Yes. Anything to submit, Mr. Khatonier?
Apparently.
How can we give them a time frame on these instructions? They are seeking a view of the senior accounts and finance officer. We can only say that the views may be expressed within a particular time frame. But whether these views are in your favor or against that, we cannot direct them. We can close it on that, or we can defer it by another 2 weeks or so.
Lordship may kindly dispose of, otherwise, Lordship.
All right, heard learned counsel for the parties. This writ petition is filed by the petitioner. Who are the regular employees of the Assam State Textbook Production and Publication Corporation. Pursuant to the views expressed by the various, pursuant to the discussions of the employees along with the management and other stakeholders, the Assam State Textbook Production Publication Corporation Limited Employees Pension Trust was set up. All clearances from the necessary departments have also been obtained. Actuarial liabilities have been identified, and on the basis of an report, and the administrative department has also granted NOC. However, the fund has not yet been operated, because of which the petitioners apprehend that the authorities, respondent authorities, more particularly the administrative department, namely, what is the department? Administrative department,
Department of School Education.
Department of Education, School Education, may act contrary, may not proceed to implement the may not proceed to implement the decision arrived at pursuant to the discussions between the employees and the other stakeholders. Stop. On 13/2/2024, this court had granted the respondent authorities to obtain required instructions. Para. Today, when the matter is called up, Mr. I. Thakur, Learned Standing Counsel, has placed before the court an instruction received from the Managing Director of the Assam State Text Production and Publication Corporation Limited that the matter is under active consideration, and the views of the Senior Finance and Accounts Officer of the School Education Department are awaited on this and are presently awaited. Stop. On these instructions, Mr. Thakur, Learned Counsel for the respondent, submits that once the views are received, the department will pass appropriate orders to proceed with the trust which is set up, to proceed with the pension trust which is set up for the benefit of the employees. Where Mr. S.K. Das, Learned Counsel for the petitioner, submits that the writ petition may be closed with a direction to the department to expeditiously process the claims. Where, taking into account the submissions made by the respective counsels, this court is of the view that the writ petition can be closed with a direction to the respondents, all the respondents, to expeditiously take a decision in the matter, or in terms of the earlier decision arrived at to set up a pension trust for the employees of the so-and-so corporation. It is expected that the decision will be taken within 30 days from the date of receipt of a certified copy of this order.
Since the managing director is also the secretary of the Elementary Education Department, he is the person who needs to issue the notification. He is also holding the dual post. He is also the secretary of the.
No, but it is not pending with him. He says it is sent for the views of the.
It is under him, Lord, the senior finance and accounts.
Then you'll have to make him a party if you want it. The exercise be completed within 30 days from the date of receipt of a certified copy of this order. Information disposed of. Mr. Khatuniar for education, Mr. Sudari for finance.
Petitioners are seeking certain components of VRS which were left out.
Why after so many years?
My lord, what happened is, my lord, there were some employees who were picked and they were absorbed in the irrigation department. I, expecting the same, agitated my grievance before this court, and finally my entire matter ended in the Supreme Court in the month of March 2023. Now, having no other option, my lord, of getting absorbed.
What was the decision of the Supreme Court?
It was dismissed. It was dismissed.
Yeah.
Now, since I'm not to be absorbed, so I availed the VRS at that point in time. I was under the impression that if I am absorbed, then I have to return that amount. So now the components which are left out, that is all I am taking, nothing else.
But
is there.
VRS must have, the scheme must have ended by now.
My lord has allowed quite a number of cases, this court has allowed quite a number of cases covered by a
Do you have any orders?
Yes. Page 123, it starts, the effective portion starts from 137. This is of 19th of December 2020. Similarly,
What-
cases.
Similar order. Yes. Any objections, respondents? Okay. Heard, disposed. 137.
Apply.
Kindly give your names. Okay.
Lordship, non-payment of this provident fund amount, my lord, due to non-receipt of exist date of this.
It's not maintainable here. You have to go before NCLT. Your grievance is against respondent number 3,
My lord,
who is the liquidator.
my lord,
Who has appointed the liquidator? The liquidator is appointed in pursuant to orders of the NCLT.
my lord. Petitioner,
So you go, if your claims are not answered,
yes,
your first forum would be the NCLT.
my lord, that this is notice may be issued only.
No, why notice? It's not maintainable. On the first place. Who's for the respondents? Who will appear for the respondents?
Respondent number 3 is.
What is the point in issuing notice to be told that this writ petition is not maintainable? We are telling you now, not maintainable. You should approach, which NCLT had passed these orders? Delhi. You'll have to approach, examine your possibilities to agitate the matter before NCLT Guwahati. Union of India. Who's for the union? You get a counsel for Union of India. Yes.
My lord, the petitioner is a grade 4 employee. His appointment is purely temporary basis. Now, he, by Annexure 2 at page 16, was sought to be transferred from Binakandi ICDCS project Hojai to Lanka ICDCS project. My lord,
Binakandi is where?
my lord, only thing is, he's a temporary employee with fixed salary below 20,000, my lord. If he is transferred, my lord,
What is the difficulty he faces? Half an hour.
but he has to, there's transportation cost, that is there, my lord. It's a temporary employee, my lord, it's a pure, my lord, great for employee. What necessary, my lord? Why this necessary?
You get instructions.
Lordship, it's a clear case, Lordship.
No, his case is that he's a temporary employee.
Yes.
Why are you transferring a temporary employee?
Lordship,
You get your instructions,
Yes,
Mr. Goswami, that's what we say.
Lordship.
We'll not issue notice at this stage.
My lord, let him take instruction, my lord.
Let him
Till
take.
such time, my lord, I may be protected.
No, Lordship.
When was the order issued?
My lord, 9 February, my lord. And thereafter he is on leave from, he suffered from some heart disease, my lord.
Where is that order? Impugned order of transfer?
Impugned order.
16, page
Page
16.
16, my lord, Annexure 2.
Okay, you get instructions, heard, and counsel for the parties. Grievance of the petitioner is that he is a grade 4 employee. Where have you stated you are a temporary employee?
Yes, my lord.
in the appointment letter, madam, at page 14, madam.
The petitioner is working as a grade 4 employee in Binakandi ICDS project Hojai as a peon. He is agreed by the order dated 9th of February 2024, whereby he is transferred to ICDS project, Lonka ICDS project Hojai, against a vacant post in the same scale of pay and capacity. Petitioner claims to be suffering from health ailments which require medical treatment. It is submitted by the learned counsel for the petitioner that he is still serving as on temporary basis and his service has not been regularized. Under such circumstances, there was no occasion to transfer a temporary to transfer the petitioner who is under temporary employment. Mr. J.K. Goswami, learned counsel, appears for the respondents. Let the Government Council obtain the required instructions in the matter. In order to enable him to obtain instructions, extra copies be furnished within 3 working days from today.
Yes.
Matter be listed again on 18th. Till the next returnable date, the
Lord-
impugned order may not
Lordship,
be
Lordship,
will not be acted upon.
Lordship, on that count, Lordship, I would like to.
Issue notice on the interim prayer. Yes.
Regarding the interim payer, Lordship. So far, what he is submitted before this honorable court today itself regarding
We are giving you protection till 18th. If you can get instructions on an earlier date, you tell us.
Lordship,
11th, we can fix it on 11th.
No, Lordship, there is no bar for a temporary employee to transfer to one ICDS project to another, Lordship.
No.
There is no
Mr.
bar,
Goswami,
Lordship.
if you want to submit, we'll record your submission. If you want to get instructions, you get your instructions. Are you instructed to submit?
No, Lordship, at the same time, but so far what he stated before this honorable court is that due to his financial hardship, he is not able to. That was not in his pleading.
There is a statement here that he
No, there is no pleading. That was not his projection.
The attitude of government councils against stay orders is not appreciated. We are giving stay because we feel it is necessary. You are aggrieved, you go in appeal, file a vacating petition. You don't have the instructions today. Do you have instructions in the matter? You tell me that you have instructions at 2 o'clock, we'll take it up the matter. Get
Yes,
your
Lordship,
instructions.
I will.
All
I
right.
will. Yes, I will.
But merely saying that because there is an interim order, you are aggrieved without any instruction. You don't have any contrary instructions.
I will. At 2, Lordship, kindly fix the
Very
matter.
well, but if you don't get instructions, we are making the stay absolute. Be wary of that.
Lordship, but so far, I have to contact with the.
We are giving you time for that. We are giving you time.
Lordship, kindly fix the matter on Lordship. It's 27, Lordship. 27.
We are fixing it on 11.
11, Lordship. Because grade 4 employee, Lordship.
All right. When do you want it?
Yes, Lordship. Next week, Lordship.
Next week is not possible. We can have it on the week after. We can have it on 4th, 6th, 8th. Tell us.
4th, Lordship.
4th. Matter be stayed till the next returnable date, list on 4th. By which time the government councils will obtain required instructions in the matter.
Deeply okay.
May it please your lordship.
Hmm.
Lordship, the petitioner before your lordship is claiming, my lord, his monthly as well as area salary, my lord. The petitioner's case in brief is that, my lord, the petitioner was appointed against the sanctioned vacant post under.
For which period? For which period?
From,
2018, 19.
Yes, my lord, March 19, he is not receiving his salary, my lord.
Why have you come today after so many years?
My lord, his candidature was forwarded, my lord, for finance approval, my lord. Page, my lord.
Yes, who's appearing? Karbi Anglong. Third Learned Council for the parties issue notice, returnable 4 weeks. MS
S. Kempra.
S. Kempra appears for the Karbi Anglong Autonomous Council. 1, 2, 3, 4, 5, 6.
No, Lordship,
1,
4,
3,
5 and 6, Lord.
4, 5, and 6. What about 1 and 2? 1 and 2 you're appearing? MSM Bhattaji for 1 and 2, Mr. Borpujari for 7.
Lordship, yes, Lordship, 1, 3, 4, and
1, 3, 4, whatever
And 5.
they're appearing.
4, 5 and
And 8, who's appearing? Secretary PWD, Ardhor. Okay. Extra copies be furnished within 1 week from today.
I am deeply obliged, my lord.
Right, this is a Lordship. This is a case, my lord, in connection to area salary of the petitioner, my lord. My lord, may kindly come to page, my lord, 41. The proposal has been submitted, my lord, to the Director Elementary Education, my lord, for payment, my lord. But till now, my lord, I have submitted representation that has not been considered, my lord. Lordship may kindly come to page 41, my lord.
41.
Yes, my lord. This is the bill, my lord, proposal bill, my lord, that has been given by the District Elementary Education Officer, my lord, on 4/2/2022, my lord. Enclosing all relevant documents, my lord.
Then what happened?
My lord, then thereafter, my lord, then page 42 is a non-royal certificate, my lord. This is DIR, my lord. The bill has been submitted. But since then, my lord, I am submitting my representations, my lord. I have also submitted letters on page 50, my lord. So that has not been considered as yet, my lord. So may I pray, my lord, they will verify, my lord, and they will consider, my lord. Because similar way, there's a judgment of this honorable court, my lord. I'll just place one, my lord. His lordship.
You wanted disposal of your representation.
Yes, my lord.
Yes, Mr. Karunier.
As regards disposal of representation, I have nothing to say, my lord, but as regards his proposal of area salary, my lord, page 51. The earlier proposal was, some discrepancy was there, my lord. That is why director sought for new proposal, my lord.
New proposal has been given, my lord.
That information is not here, my lord. Whether new proposal has been submitted or not.
Let them verify, my lord. If I am entitled, my lord, then they will pay, my lord.
No, sorry, what were you pointing out at page 51?
Page 51, my lord. This is the letter issued by the director, my lord, to the district elementary education officer to submit fresh proposal with this format, my lord. Page 52, your name of petitioner is there, my lord. Serial number 4. Alia Begum.
No, my lord. This page 51 is basically, my lord, for budget proposal, my lord. And this letter has been issued to all the district elementary education officers, my lord. So in that list also, my name is there, my lord. District authority has sent, my lord, that.
What is the name of the petitioner?
Alia Khatun, my lord. Alia Begum, my lord. Alia Begum.
Page 51, last part, my lord. You are requested to submit head-wise, DDO-wise, TO-wise, teaching and non-teaching staff-wise, general court case-wise, requirement of funds separately as per format above, immediately for making head-wise budget provision during the financial year 23-24.
Has it been submitted or not?
That information is presently, I don't have.
Where is your representation?
My lord, page 50, my lord.
And what is this order?
The similar, my lord, similar case, my lord, arrears salary, my lord. The relevant is the last paragraph, my lord.
No, why fresh? Your representation
yes,
is already there.
yes,
It
my
is on
lord.
filed on 5/1.
Yes, my lord. I've already filed, my lord. If necessary, I can file a fresh one for my.
No, why should you file a, why
No,
should we
not
permit you to file a
Yes,
fresh
yes,
one?
yes.
Okay, heard, disposed of. J to similar order, but here there is a direction to file a fresh, so it is not required here. Okay, disposed.
Obliged, my lord.
You dispose it off within 30 days from the date of receipt of a certified copy of this
My
order.
Obliged, my lord.
Please, Your Lordship, this matter may be adjourned for the day, Your Lordship. The conducting council has some family matter.
Adjourned to be listed
Obliged.
after 1 week at the request of learned counsel. May your name?
R. A. Majumdar.
R.A. Mazumdar, learned counsel for the petition.
Obliged.
Yes, she has a grievance of some claims
That's it.
against not being resolved by the respondent number 3, who's the liquidator.
That's it.
So what do you have to submit?
Nothing on this case. That's it. Next week, which will be fixed, I will take instruction, that's it, because I have no instruction in this matter.
No, because this liquidator is appointed
That's it.
under the orders of the NCLT.
That's it.
So normally, if there is a her claims are not addressed, NCLT is the forum.
That's it.
That is what we wanted
Okay.
you to find out. You tell us on Monday. Monday or Wednesday?
That's
Matter be listed again on 28th
Thank
February.
That's
On which date? The learned CGC, MSRDP will apprise the court with regard to the maintainability of the writ petition. List on 28th of February. Okay?
That's obliged.
Any objections?
Lordship, I am appealing for the liquidator, Lordship.
Oh,
On the last occasion, Lordship asked to seek information.
what is the issue here? Retirement benefits.
Retirement benefit. But they have not provided me any copy.
We just handle the matter, I think the last item.
Lordship, that was also for liquidator.
Are you representing the liquidator? No.
I am representing the liquidator.
Then we fixed it on 28th, I think.
This matter.
No, last matter.
Last matter, Lordship fixed it on 28.
So we'll fix this on 28th also, since the petitioners haven't appeared. None appears for the writ petitioners. Matters be listed again on 28th of February. Mr. P. Das appears for
P. Chaudhary.
Chaudhary appears for liquidator. And Mr. N. Kolita for
Industries and commerce. That's one number
industries.
7.
Respondent 7.
Lord.
Yes, you are appearing for
AIDC matter.
AIDC. Mr.
Yes, that's.
S. Das appears for AIDC. List on 28th.
In item number 9 also, my lord.
Sorry?
In item number 9, my lord. The
9,
last
9,
item.
yes.
There, my name may be recorded.
Mr. P. Chaudhary appears for respondent number 3 in item 9. Call it up again on 28th of February. You try to get an extra copy from the council. She's not here. I don't see her. Yes.
Lordship, on the issue, the interpretation of that word M, my lord, Mr. Pujari.
We'll take it up in the second half. At 2. You'll like to dispose it of today
Yes. I'm already prepared, my lord.
at 2 p.m.
2 p.m. Yes.
because this will require some hearing and we'd like to, if possible, dispose it off.
Lordship can dispose it of today itself.
So at 2 p.m. Yes, Mr. Talukdar.
My lord, in fact, in this case, they are employees of a cooperative bank, my lord, and they are asking for VRS from the government. In fact, my lord, there are judgments of the Honorable Supreme Court as well as recent judgment of the Honorable Division Bench also that the employees of a cooperative society not being employees of the government, my lord. So therefore, the government is not responsible for payment of the salary. And in the present case,
who is for the petitioners?
Well, in fact, none has appeared.
Okay, none appears for the petitioner. Next week, Mr. Talukdar appears for
Cooperation Department.
Cooperation Department. Mr. Anyone else? Mr. Finance. Harbor Pujari for Finance. For Finance. MSA Talukdar for respondent number 1, Chief Secretary. Matter be called up after a week.
Lordship, we are seeking time to file reply on affidavit.
Item 18 at the request of Mr.
Arbez Barua.
Arbez Barua. Matter stands. This is that pension. What reply you are going to file? It's covered by judgment of the Apex Court. The request of Mr. So-and-so matter stands adjourned for 2 weeks. 2 weeks to be listed on a date to be fixed by the registry. Mr. N. Deka appears for the
Respondents.
The respondents, all the respondents.
Not all the respondents, I'm sorry, madam. The private respondents are there.
This is IUC.
This is IUC.
Appears for IUCL.
No, madam, there are no private respondents, all the respondents.
All that. Okay.
Okay.
May I please, Your Honor? Lordship, kindly adjourn the matter for the day, Lordship.
Why?
But I'm told the CGSC is engaged somewhere else. But then this man is 77 years old, my lord.
What is he asking?
He's asking for, my lord, there is a wrong fixation in his pension by 70 rupees and some medical allowance, my lord, of around 30,000 rupees. He's 77, my lord, if it can be taken up in the first week of March.
First of March. Matter be listed again on 1st of March as it is submitted. As a prayer for adjournment is made on behalf of the CGC.
CGC, Lordship.
Who is the
This is
CGC?
A guy, Lordship.
MSA guy. As agreed to, matter be listed on 1st of March.
Can it be on 5th, my lord? First, my lord, engagement is there.
It will have to be 4th or 6th. You pick your date. 4th of March.
Obliged.
May it please your lordship. Petitioner was selected, my lord.
Yes.
As per advertisement on 3/9/91, my lord, petitioner was selected on select list was published on 4/1/1995, my lord. Then his name is shown in the select list. Page 21, 17. The person who is below than him but they were appointed, he was not, my lord. Immediately he came, approached before this honorable court. This honorable court passed an order, page 25, to consider the case of the petitioner. And accordingly, as per orders, he was appointed on 24/12/2005, my lord. In this case, my lord, the question is whether he will entitle for pensionary benefit or NPS or GPF, my lord. Since he was appointed as per my lord advertisement in the year 1991 and published on 4/1/95, my lord, so he.
Where is the earlier order of the court? Some order was passed.
Yes,
by
my lord, that
year
is page 25.
25.
And he made party also, my lord, the person who is below than him. Similar order.
Then what happened?
Then, my lord.
After the order of the
Yes,
court?
my lord, he joined, my lord. Since then he filed several representation, my lord, before the concerned authority to file GPF because the similarly situated person have already been getting GPF, my lord. The person who has already been appointed, my lord. Since his appointment was 2005, my lord, they are not provided pensionary benefit, my lord. That is my case. But a similar cases already been passed an order, my lord. May I place before your lawsuit, my lord? This case also covered by this.
Covered, you will have to say that your appointment after the cutoff date is
Yes,
not
cut
because
off
of
date.
your fault.
Yes, because what happened, my lord? If he approached 2023,
Yes,
if
that-
he would have been appointed before
No, that is why we wanted-
2004,
that is
then
why-
he would have been a
Correct.
question to approach this honorable
So
court.
on what basis are you making this statement that you were wrongly, you were not, you were not appointed for reasons which cannot be attributed to you? The order which you pointed out at page 25 relates to merely disposal of the representation.
Yes, my lord.
There was no finding.
Yes, my lord.
Then, in your synopsis, you say that you were not, you filed some contempt petition.
Contempt petition
Where is that
also, my lord.
contempt?
Contempt, I have not annexed, my lord, contempt petition.
Then what is the stand of the?
I have no idea, my lord. So
Huh?
I have no idea.
You are the
regarding
counsel for the petitioner.
contempt.
Who will have the idea?
My lord, I have to obtain, my lord, all
You-
instructions.
You
regarding
obtain
this.
instructions.
Yes.
Where is the
My
affidavit
lord,
of?
in page, my lord, 28, lordship kindly peruse the 28. Inspector of Schools, my lord, forwarded a letter to the director and showing that for application for opening new GPF, my lord. On basis of that, your lordship can pass an order, my lord, because he has already been filed an application to the director for opening new GPF,
Where is
not
that?
NPS.
Where is that?
Page 28.
28.
And I have filed several minor representation before the concerned authority.
No, your prayer in the writ petition is for what? It's for granting the pensionary benefits.
Yes, pensionary benefit under rule 1969, madam, service
Ah.
pension rule.
But you have not
And
been,
lordships in another no, it drop no fight. My lord, Honorable Justice Guru also stated in his judgment, my lord, the person who is appointed, who was selected, my lord, 2000 after 2005, and they were appointed stipendary, they will also entitle for pensionary benefit.
correct. That is what we are asking you, that
Yes.
your selection was earlier,
Earlier,
but you have not been appointed. For whose fault? Is this something to do with you? You did not join your.
My lord, at the time, pick and choose manner was happened, my lord. Was
Therefore,
held.
we
That's why
wanted.
he approached this honorable court.
Therefore, we wanted to find out that contempt order. You read your synopsis. Your synopsis projects a different.
My lord, give me some more time
All right,
regarding contempt, my lord. Next
You
week,
find
my
out next week. Yes, list next week.
next week, my lord. 28, my
On
lord.
4th, let it be on 4th, 4th of March.
Okay, please.
on 4th of March.
Hey, একটু heavy নহয়, drop না।
Prayed for by learned counsel for the petitioner, Mr. N.J. Khatoniar for education, R. Borpujari for finance, M.S. J. Das for accountant general.
কি বলবো? So similarly, order also there, my lord. The person who has already been appointed 1991, advertisement.
I
and-
know it is there, but you will have to tell us that his appointment came deliberately, the delay has been caused without your fault, but that is what we're trying to find out in the petition. Your synopsis says so, but I am unable to find in the body of the petition.
Yes,
So therefore, perhaps there is some reference to that in the contempt order.
yes, contempt order is there. Yes,
So you can place that contempt order on the next date.
yes. Contempt number.
And any other judgments that you want to rely on.
Yes, my lord, I have.
Of like. 23, 24, 48, 49. These all relates to.
These are all, my lord, illegal and irregular appointee, my lord. I have received some instruction, but which is not sufficient, my lord. My lord may give me 3 weeks time, my lord, so that I can complete my instruction.
Well, let them 2021 matter, my lord, maybe a fixed date, my lord. Take it out.
Your salary has not been received.
Yes. I don't think the pilot.
Okay, heard learned counsel for the parties, Mr. N.J. Khatoniar, learned counsel for the education department. Which education? Elementary.
Elementary, my lord.
Submits that instructions are not complete, you prays for further time. According Mr. Biswas, learned counsel for the petitioner, does not object. Matter be listed after 2 weeks. How much time you require?
3 weeks, my lord.
3 weeks. Enabling him to complete the instructions and file necessary affidavit. Matter be listed again on 1st of April?
Yes, my lord.
1st of April, by which time the respondents may file their affidavits if so advised in the meantime. Item numbers 21,
The item 23, 24, 48, 49, same.
23, 24, 48, 49 be listed together on 1st.
I'm deeply.
Obliged.
This is my lord. For recovery, it is recovery by the department against the petitioner who retired from service. The claim of the respondents are that the fixation was wrong, that they committed a mistake while fixing his pay at the initial stage of after his appointment. So after retirement, they even noticed it and they issued notice that he should pay the excess amount which was paid to him. So therefore, we have come up before this honorable court that he was a grade 3 employee, my lord. Honorable Supreme Court has also passed such judgment, and Honorable Guwahati High Court has also. And thereafter, my lord, the Finance Department, Government of Assam has also passed a direction that no such recovery will be made once the payment is made to grade 2 and grade 3 employees, grade 4 and grade 3 employees. So at page 27, this initial order is there. That his page 27, my lord, and certain
Yes.
that his pay was to be fixed at 542, but instead it was fixed at 544. And that came up so and thereafter they calculated it after his retirement, it amounted to 3,24,974 rupees. It is at page 28. They have calculated the amount of excess payment. So, my lord, as per the observation of the Honorable Supreme Court, Honorable Guwahati High Court, as well as the notification of the Finance Department, the petitioner is not required to pay back the amount, and whatever he has been compelled to deposit, it should be returned to him.
It has been recovered already.
My lord, he has been forced to
Deposit.
deposit, my lord. He has already deposited that amount.
Yes, Mr. who's appearing here. Someone has filed the affidavit.
No.
Commandant,
Which department has?
respondent 7. Anyone appearing?
In one, my lord, similar judgment that my lord will find at page 33 of the writ petition. It starts from page 33, lordship may be pleased to come to page 35.
35.
35. My lord, here, my lord, this honorable court has relied on my lord Rafiq Masi and Syambabu Burma. Now, my lord, in Rafiq Masi, my lord, at page 35, my lord, my lord, the ratio has been, my lord, quoted. Lordship will kindly say it is not possible to postulate situation of hardship so. We may, as a ready reference, summarize the following few situations where recoveries by the employers would be impermissible in law. Number 1, recovery from employees belonging to class 3 and class 4 service of group C and group D. Now, petitioner herein, my lord, will, and my lord, pursuant to Rafiq Masi decision, my lord, the finance has already issued an OA, my lord, incorporating the same dictum, my lord. Only with a rider, my lord, that if the recovery is more than 1 lakh, my lord, then sanction, my lord, approval of the finance has to be taken, my lord. Even except that, my lord, the dictum at Rafiq Masi, my lord, still holds the field. Now here, my lord, he will have to prove, my lord, that he was a grade 3 or grade 4 employee.
You look into his employment, he was appointed as a typist, LDA or something like that.
My lord.
Para number 3, page 5. He was temporarily appointed as LDA, some typist. That's a grade 3 post.
Yeah.
Then 4, he was working as LDA assistant.
Yeah.
Promoted to UDA.
Retired as UDA.
UDA. UDA is grade 3 only.
Grade 2, my lord.
Grade 3.
Appointment.
Then if you come to the affidavit filed by respondent 7,
My lord.
para 6, there is an averment that there is no averment that this wrong fixation was because of his fault.
Yes.
No averment.
And if only there is an element of fraud, my lord,
Exactly.
then yes, only then.
Then otherwise it is not there. It says he has been called, he has been informed, his amount has been asked to be deposited, overdrawing of salary, etc.
Yes, and his appointment letter, lordship will find at page 17, 17. Only to that aspect, my lord. Page 17, you are hereby appointed to officiate temporarily as LD assistant come typist.
Whatever, he was regularized. I mean, he retired, he superannuated as a grade 3.
Yeah.
Had it not been grade 3, perhaps
yes,
it could have been looked into.
Yes.
And there is, in view of the affidavit, there is no averment that it is because it is by the commandant.
Yes, because it is only the employer, my lord, who can disclose.
Exactly.
Yes. Who can disclose
So
what is the
therefore,
nature of
it
appointment.
is may not be proper to say overdrawing of his salary because technically he gets the salary what is earmarked for him.
Yes. Even if someone gets more, my lord, without any fault, my lord, the employer will have to face the music. This is what, my lord, is the ratio in Rafiq Masi.
Right. And there is no averment that he has submitted anything false or
My lord.
falsification of documents, nothing like that.
My lord.
Yes, who's for the state respondents? Anything to submit now? Respondent 7 has filed the affidavit.
Lordship, from the submission of the petitioner, it is said that he already has paid the amount, Lordship.
That's right.
Yes,
So
Lordship.
according to him, it ought not to have been recovered.
Yes, as the person has retired, Lordship, and there was observation from the Accountant General Office, Lordship. So for his benefit only, Lordship, for early settlement of pension, as it was detected, Lordship, there was overdrawn payment of certain amount, Lordship. So for this only, nothing has been there against the petitioner, Lordship. This is only for his own benefit, Lordship. he has been called and he was asked to deposit so that his pension can be regularized and can be paid at the earliest lodge.
In your case, it has already been recovered.
Yes, Lordship, this is.
What do you want? You want it back?
Yes, my lord.
You can't get it back. There is an error.
No, because they forced us because they have written us letter that you pay it, otherwise you will not be.
Rafiq Mashi and the subsequent judgments are at the time
Huh.
when recovery is imminent, is sought to be recovered. Then the court says grade 3, 4 don't recover. Here is a case where you have already paid.
We have paid money under forced circumstances, we have paid.
Do you deny the fact that this pay scale is not correct?
Because they have done it, because we have. not done it.
Correct. The
I did
Rafiq,
not have any role to play, my lord, here.
no, you are quite right. Ordinarily, whatever money is not entitled to you, you have to give it back.
Yes.
That is what the financial rules are. But in view of Rafiq Mashi, in cases of grade 3 and grade 4, even if some wrong payment has been made, it should be released.
Not to be recovered.
Not to be recovered. But in your case, it has already been recovered.
Recovered means under forced circumstances, my lord.
Whatever it has been, you show us a judgment that following Rafiq Mashi, it should be returned back to you. Do you have anything?
Because they should not have forced us,
But you came late.
my lord.
You came late before this court.
No, my lord. it did
Of
not.
course, you should have. When was it recovered? When was it recovered? 21.
Yeah.
21.
I deposited by the 30, case 30, I deposited on 21/4/18.
So you should have come before depositing the amount.
Bird also, Lordship, time bird.
Because what happened, these legal provisions were not known to the customer. This is fairly submitted because these legal provisions, the Honorable Supreme Court judgment, Honorable High Court judgment, and notification of the central.
Correct. All these judgments are at the stage where recovery was sought to be made.
Because it was not within our notice, my lord.
Quite right. But you have already given back the money.
Money, they have taken back the money.
Given back and taken back is amounts to the same thing.
My lord, they have forced us under force, they have.
Quite right. Now you show us a law that notwithstanding that following Rafiq Mashi, the amount is to be returned to you. You do not deny that this is wrong fixation. Is it your stand? Is it your stand that the amount which has been recovered ought not to have been recovered because this is the correct pay scale?
Yes.
Is that your stand?
We will not say it.
You're not telling that.
We will not say. Because I am a poor employee, go to grade 4, thereafter grade 2, grade 3. And all this time I am paying by bit, it has come to 3 lakh.
Now
This will be iniquitous. If it is recovered as per the judgment of the Honorable Supreme Court, it will be iniquitous.
then you will have to enlighten us with the findings of the judgment. You take us to the judgment, Rafiq Mashi, let us see. Do you have a copy of the Rafiq Mashi?
Yes, my lord.
Rafiq Mashi judgment.
No.
Yes, please take us to the judgment. Come to para 3 of the judgment. Para 3.
Yes, sir.
Kindly read. Please read.
The issue that we have been required to adjudicate is whether all the private respondents against whom an order of recovery of excess amount has been made should be exempted in law from the reimbursement of the same to the employer for the applicability of the instant order and the conclusions recorded by us hereinafter. The ingredients depicted in the foregoing two paragraphs are essentially indispensable. 4. Merely on account of the fact that the release of
the issue here is an order of recovery in Rafiq Mashi.
Yes.
It's there in para 1 also.
My lord.
This is the facts of the case. So the amount was, they have received the amount.
They did not deduct the amount. They did-
Exactly.
so while paying the arrear benefit, they did not deduct the amount from any of the heads. After payment of the entire amount, they forced me to return it. That is the difference is there.
That's right.
That's the
So,
difference.
so once the amount is,
They did not recover it while paying the amount. There were areas, GPF and other amounts, they did not recover it at that time. Entire amount was paid to me and thereafter they forced me to deposit.
but that amount which you received,
My lord.
according to you, is it a lawful claim?
Lawful claim, not lawful claim, my lord, but the department has done it, department has paid it, department has by years after years.
But as an employee, you are aware your pay scale.
Whatever, my lord, I been aware because department could have recalled after issuing notice.
No. As an employee, you are aware of the scale of pay.
Because they have fixed it because this grade 3 and grade 4 employees, because they are not so well versed that they will go all these things.
Yes,
Whatever
but
have been paid.
that's
they
all
will
right.
take it if they are receiving it.
But in this judgment, the decision is at the time when the recovery was sought to be made. This judgment. In your case, recovery has already been made. You are asking for a refund.
Yes, ma'am.
For that proposition, do you have any other judgments? Or would you like to refer to any other judgments?
These are the available judgments, ma'am.
Yes, respondents, anything you submit?
Lordship, it was only the overdrawn, that means pay DCRG and leave salary, Lordship, and it is admitted that he is not disputing that this has been paid excess to his entitlement, Lordship.
He says he
And
doesn't
he
know.
has deposited, Lordship, and there is nothing force, no amount of force is there, Lordship, only letter has been issued that his pension can be settled at the earliest, Lordship, and this is for his own benefit only. And he has willingly deposited, Lordship. And if we at all, that means into this Lordship, this is also time barred, Lordship. He should have filed it within the 3 years of his deposit, Lordship.
Is there any order of this court directing refund of amount deposited? Do you have?
This has not come to my notice, my lord.
You make an inquiry and find out if it is there. When were the payments made?
2018 page 31, Lordship, of the writ petition.
Excess salary.
Yes, Lordship. And
And
through
re-
treasury challan, page 30, Lordship.
No, not recovery. The salary which he received, excess salary.
Yes, these are all deduction, that means of the final settlement amount, Lordship.
Any judgment? No. We are keeping it next week. Have a look. Next week. The request of learned counsel for the petitioner matters deferred for a week. Ms. M.S.M. Bhattacharjee for state respondents, Mr. S.K. Medi for accountant general, Mr. R. Borpuzari for finance.
Obliged, Your Lord.
Yes,
May I please your lordship? Lordship,
some
in this
affidavit is filed.
No, lordship, they have not filed their affidavit.
No, they filed. 2, 3, and 4 have filed. You have not received a copy?
I'm not sure.
You want to file a reply?
Lordship,
MS A. Talukdar, learned counsel for the petitioner, praised for and is granted 2 weeks' time to file reply affidavit to the affidavit in opposition filed on behalf of respondents 2, 3, and 4. Matter stands adjourned to be listed after 3 weeks. Mr. Mushari appears for BTC. They filed.
okay, I don't have the copy. I don't know, sure, I'll. That's okay.
Yes, Mr. Rama.
See,
Yes,
the method is payment of arrear salary.
area itself.
Arrear salary.
But yesterday, director has submitted a proposal to the government for sanction. Yesterday,
For the same period, for the period indicated.
Yes, madam. Total amount is 2,64,887.
You show it to Mr. Counsel. Heard learned counsel to the parties, Mr. N.J. Katonia, learned standing counsel, on instruction submits that a proposal has been put up before the secretary,
Madam.
school education, for payment of arrear salary to the writ petitioner as prayed for. Accordingly, he prays for further time to apprise the court on the proposal, on the status of the proposal submitted. Matter be listed after 3 weeks. Meanwhile, the respondents will endeavor to process the proposal and get the necessary sanction for release of the area salary as prayed for. List after 3 weeks.
Okay.
May I please the lordship? Lordship, I'll file an additional affidavit. May this matter be taken up on the next week?
Learned counsel for the petitioner prays for 2 weeks' time to file additional affidavit to the affidavit in opposition filed by respondents. Which
For the
respondents? All respondents.
1 to 6 miles.
1 to 6. Matter stands adjourned for 3 weeks. MS so and so for petitioner, Mr. Dotto for the respondents.
I'm on behalf of NBPC petitioner advocate. He's suffering from illness, but he's not present today. At
the request made by on behalf of the writ petitioner, matter stands adjourned for 2 weeks. Mr. Goswami appears for the respondent. State. Yes, Mr. Alam.
My lord, for arrear salary of the petitioner.
Well, here, retention was not there, Malad. So where send a proposal for ex post facto retention, but we are yet to receive that from the government, Malad.
Ex post facto to be granted by whom?
The director, Malad. Not for an approval from the government, Malad.
Where was it submitted? When was the proposal submitted?
Proposal submitted, my lord. In our affidavit, my lord, page 16.
There is no pagination in your affidavit. Tell us the paragraph. Para 14.
We have mentioned in the paragraph 13, my lord. Page 5, paragraph 13.
Now the director has received the proposal.
Director have sent the proposal to the secretary, my lord. It is pending with the secretary, my lord, presently. Yesterday, I have received an instruction from the government, my lord, from the director, my lord.
Yes.
They have made
Heard.
some query.
Learned counsel for the parties. The claim of the writ petitioner is area salary for the period 27/3/2001 to 31/12/2016. Stop. The respondents have filed an affidavit wherein it is stated that there was no retention, initial retention at the time when the petitioner was appointed. Therefore, a proposal for post facto approval for the retention is required, which was called for from the office of the BEEO. BE or DEEO?
Yes, madam.
Stop. Today, Mr. N.J. Khatoniar, Learned Standing Counsel, submits that the proposal called for has been received and has already been forwarded to the Secretary, Department of School Education. Stop. It is submitted that present status of the proposal before the school Commissioner School Education is not known, and he prays for further time to update on the said instructions. Mr. Ayalam, the counsel for the petitioner, does not object to the prayer made list after 3 weeks. Meanwhile, the department will ensure that the proposal presently stated to be pending before Secretary School Education is examined and necessary orders required are passed in the said proposal.
My lord, a date may be fixed. It's possible.
1st April.
My lord.
Here, my lord, I am praying for some more time to obtain instruction, madam.
You don't want instruction?
No, I said that let there be a fixed date so that, my lord.
You don't want him to pray for instructions before you submit?
No, I want him. I told him, he may, after all, they are the.
Yes, now tell us what you want to submit.
My lord, if they want to file an affidavit, be that so, my lord, just only a fixed date may be given, my lord, because it is also 2022 writ petition.
What is your prayer here?
Salary and, my lord, because his salary, he has not received his salary, man.
These are matters which are not decided by the tribunal.
No, my lord, this is.
What is the tribunal?
Tribunal regarding, my lord, provincial election, my lord.
Only provincial.
Provincial election, my lord. Dispute regarding seniority and all, my lord, before at the census stage.
Because these, you see, these require assessment of facts. And most of the facts are never available before the court.
Furnish the record.
No, but it's not the duty of the court to go through the record and find out what is the fact. So if there is a fact-finding authority, then at least we have to decide on the applicability of the law. Isn't it? But every matter, area salary, stipendiary teacher, not approved, post retention not done, who is responsible for that? Why was it not done? How a person is working for 10, 15, 20 years on a post which is not retained? Who's paying the salary? All these are factual issues. Anyway, so long we are required to do, we'll do it. Heard learned counsel for the parties, Mr. N.J. Khatoniar, learned standing counsel education. Submit, you have filed some affidavit, no?
No, my lord, no, my lord. In this case, we have
All
not
the
filed any.
instructions are not complete. He prays for further 3 weeks' time.
2 weeks.
2 weeks.
Yes.
2 weeks' time to complete his instructions and file necessary affidavit. Mr. M. Biswas, learned counsel for the petitioner, submits the matter be listed on a fixed date. List on 1st April.
All matters are getting listed on 1st of April.
Dates are available.
Otherwise also that day has some significance.
It has no significance in the judicial context.
They may come up with those things. I am obliged.
Yes, Mr. Chaudhary.
Yes, for number 3, Sonic School Golpura, also file affidavit, but the affidavit has not been filed.
Who's for the respondent 3?
Earlier they appeared.
Service is complete, but I don't think anyone appeared. Who's respondent 3?
Someone appeared Maladan earlier, they Melody, and they paid for time.
Principal. Who's for the any CGC? Any CGC available here? Mr. Dotto,
Yes, my lord.
CGC can appear on behalf of Sainik School, Gwalpara. Heard learned counsel for the parties, as per the last order 2206/2023. It is recorded that service in respect of respondent number 3 is complete. However, none has appeared on behalf of the respondent number 3. Stop. Accordingly, the court has requested Mr. A.K. Dotto to assist the court in his capacity as a central government counsel and obtain instructions from the respondent number 3.
So they are autonomous body. I can.
We find out. Let us see. On earlier occasion, CGC had appeared on
Yes.
behalf of Sainik School.
Whole management
Copy
is
may
controlled
be
by the
another-
defense ministry.
Copy may be.
Yes, yes.
Furnished.
In order to facilitate Mr. Dotto to obtain necessary instructions, the counsel for the petitioner will furnish sufficient extra copies of the writ petition within a period of 1 week from today.
During the course of the day.
During the course of the day, okay. Matter be listed again on, we have it on, give us a date,
We have to take, I have to take instruction from the,
then we'll have it on what, 15th March,
later than my lord.
later. Then 2020 March.
Phone number.
Yes.
Wait, please, Your Worship.
Yes,
My lord, we are facing financial problem, my lord. So that is why, my lord, will take some time, my lord. We have already submitted proposal to the government, my lord, for seeking grant in aid, my lord.
yes.
Lordship, first, the finance department was made a party by the order of this honorable court. And to reflect the name, we had filed the interlocutory application. So that may kindly be disposed of. It is not necessary as of now.
For
And
the IA.
IA, as the finance department has already been completed. So
Is it impleted?
yes, by the orders of the honorable court.
Which order?
Order dated 18/7/2023.
I had order was one. I had order was one.
So the name to be reflected in the computer system, we filed the IA, although he was already completed.
Okay, heard learned counsel for parties by order dated 18/7/2023. Finance department has, this will be in the miskit, IA. Finance department has already been added as a party. As such,
Lordship,
IA number so and so is filed for implement of the finance department. Is not pressed, same is accordingly dismissed. In the main writ petition, heard counsel for the parties. The respondents are permitted further time to complete their instructions and file necessary affidavit if so advised. Someone has filed affidavit.
Yes, my lord, we have filed, my lord.
Yes,
So, but their submission is the same every time, but they are not coming up with any concrete plan as to
have
how.
you submitted a proposal?
Yes, yes,
Where have you stated in the affidavit?
yes, my lord. I have annexed the proposal, my lord. Page 31, my lord.
Okay. When you have submitted it to the director,
Yes, my lord, through handloom, my lord.
so who is for the director handlooms? What is the status of the proposal? As it is submitted by the standing council ArtFed. Mr. Jahid, you are for the ArtFed.
Yes,
ArtFed. By communication dated 19/9/2022, which is stated to have been submitted to the Director Handloom and Textiles, the learned counsel representing the Department of Department of Handloom and Textile, Mr. R. Dhor, will apprise the court on the status of the proposal so furnished. Let the respondents complete their instructions in this regard and file necessary affidavit if so advised. List after 2 weeks.
Obliged.
Obliged.
Lordship, I apologize, Lordship. In the matter, item number 35, Lordship, we have filed our affidavit, Lordship. I apologize, Lordship.
You are appearing for whom?
For police department, Lordship.
Huh?
Police department, Lordship.
35.
35, Lordship.
35 is
Gokul Goswami.
Sainik School.
Lordship, respond number 2, 4, and 5, Lordship.
No, we are asking Mr. Dotto to appear on behalf of respondent 3.
Lordship.
Only
please,
3.
And for 2, 5, and 4, Lordship.
All right, 2, 5, and 4 report.
And we have filed our affidavit also, Lordship.
And then affidavit is stated to have been filed. Yes, okay.
Quickly obliged, Lordship.
Yes, my lord, my lord, a question of parity of pay, my lord. My lord, these persons, my lord, were initially appointed, my lord, the selection process, my lord. Now, my lord, they were not initially appointed, particularly from the waiting list, my lord, they were appointed, my lord.
Sorry?
Subsequently, from the waiting list, they were appointed, my lord. Initial appointment, they did not take, my lord. Consolidated list was prepared. But statement, my lord. Lordship will find the advertisement at page 18, my lord. Post of assistant district manager, data manager, 27 posts and my lord, 149, my lord, 149 posts of block data manager were advertised. Now there
Okay,
are.
what do you say, respondents? Some affidavit has been filed.
Yes, my lord, they have been filed, my lord.
Okay,
We also filed a reply, my lord.
you want to file?
We filed
You
a
have
reply,
filed
my
it.
lord.
Okay, pleadings complete,
Copy on it.
issue rule,
Well, my,
hearing.
my reference is copy. Yes, no, I'll serve.
You have not received copy. Pleadings may be exchanged, issue rule for hearing.
Obliged.
It is also covered case of Sanjita Roy, my lord. The petitioner serving more than 25 years, 1 month.
No, this is for recovery.
Recovery and another part, my lord, pension, my lord. And the petitioner overstay in service, my lord, therefore, my lord, it is recovered 2,31,000 from the leave encashment, my lord.
Recovered already.
My lord. Recovered already, my lord. Kindly see page 23, my lord, Treasury Chalan, my lord. Deposited before the
Rafiq
government,
Mashi is an authority to stop the recovery.
my lord.
It is not an authority to refund back whatever has been recovered.
Otherwise, Rafiq Mashi, it is not permissible, my lord.
No, it is not permissible, but
After retirement.
you have already given back. You are not questioning the scale of pay. If it is your case that no, there is a
No,
dispute.
scale of pay not, my lord, overstay in service, my lord.
Whatever.
But a retirement notice issued, my lord, later on, my lord. Ought to have been retired on 31st January 2017, but released on, my lord, 31/10, my lord.
We will hear the matter then.
My lord.
Matter be listed for admission hearing. Give us a date. Give us a date convenient to you.
My lord, March, my lord, 13th. 13th of March, my lord.
30th.
13th.
13th March.
My lord.
Obliged.
13 March. No, 13 March is no, miscellaneous. We can have it on 14th. 14 March.
My lord.
Mr. Hassan for Accountant General and
Madam.
so appears for irrigation.
Yes, your lord.
Mr. Nayak for
I'm hearing for finance.
DTC, Mr. Borpuzari for finance. Talukdar for department, pension department.
My lord.
Obliged.
May it please your lordship.
Yes.
Lordship, this matter relates to deduction from the salary. There are similar matters which are pending and those are to be the proceedings should be taken after disposal of the review petition. An order is also passed.
What do you
Review
say?
petition is there, my lord.
Review against?
Review, we want to recover the excess payment made to the petitioners of. And the order has been suspended.
What is the issue here?
There is a deduction from her salary, lordship.
My lord, pursuant to the recommendation of the Central Pay Commission, we have refixed the pay scale and but wrong calculation. We we have paid.
What
excess
is that? What is the review sought for? Against which order? Review sought for against which order?
Against the judgment passed by the single bench.
Where is that order?
My lord,
That order.
8 numbers of cases were disposed of by the dishonorable court, restraining the institute to recover the excess money paid. And in that case, my lord, the order was passed in the light of the Rostic Marchi case. And here, in that order, my lord, they were categorized as category number 3, but they carry the post of the petitioner carried PB2, my lord. They are also within the category of category B. My lord, the Supreme Court also said it is not applicable for the category A and B. Recovery can be made from those category, but from not recoverable from category C and D. And they have also given undertaking mulch.
It is submitted that similar issues are pending before this court on account of a review petition being filed, being review petition number
172, 2020.
172 of 2022, which is seeking a review of which order? 13.9.
The order dated 16/11, it was passed a review. I have prepared review Union of India and 2 others versus Losmin Devi and others, and a review petition number 258 of 2022.
Both are submitting different numbers. How many review petitions have been filed?
The review
8
petitions
numbers.
are filed together, Lordship.
Huh?
The review petition is filed together. Means there are 8 numbers of where
8
three
numbers.
petitions were there.
Okay. A review petition against the judgment and order dated 13/9/2022, passed in WPC 258 of 2022, and another bunch of writ petitions. Accordingly, matter be listed. After 4 weeks, enabling the petitioners to apprise the court on the status of any orders that may be passed in the review petition number so and so.
Similar.
Similar,
Yes,
Similar,
Lordship.
42 similar orders.
Petitioner is
Similar order.
similar.
Yes.
Obliged, Lordship.
May I place your lordship? The petition of applicant's court, my lord, is a area salary for the month of December 2017 to January and February 2018, my lord. Earlier, the petitioner approved this court. The court passed this order. In view of page 22, my lord, examined and released the area salary. As per this order, my lord, the IS inspector of school,
Where is that order?
page 22, my lord.
22.
There are 3, my lord.
Yes. Then what happened?
As per this order, my lord, the inspector of schools send the proposal to the director, page 23, my lord.
Yes.
His payable amount is 1,48,131, my lord.
Hmm.
But till that they have not paid this. This is the period.
This is an area proposal, page number 23.
Yes, lord. The proposal, my lord.
Does it contain any information as Mr. Khatunier?
In fact, my lord, today I don't have the brief, my lord, but as per my instruction received from the department, my lord, the inspector of school has submitted the area proposal to the director of secondary education on 22/2/2024, my lord. Yesterday, my lord, they have submitted a fresh proposal.
Heard learned counsel for parties, the prayer before the court is for grant of area salary to the petitioner. Stop. Mr. N.J. Khatunier, learned counsel appearing for the education department on instruction submits that proposal for area salary has been submitted to
The director of secondary education by the inspector
Director
of
of
school.
Secondary Education through the Office of the Inspector of Schools, Kamrup Metro,
Yes, my lord. Kamrup Metro, my lord.
which has been received by the Office of the Director yesterday. If the date, he therefore submits that the matter will be required to be examined, and accordingly, he may be permitted to apprise the court in this matter after a period of 4 weeks. 4 weeks.
Date make it.
Accordingly, matter be listed again after 4 weeks. List on 5th of April.
Obliged.
Yes.
In this writ petition, my
Why,
lord,
why the I?
IA, my lord, took step vacating the interim order, my lord. In the earlier occasion, the my lord, this honorable court, my lord, observed that my lord, the IA is treated as a my lord, affidavit, my lord.
Okay.
The
Now,
matter pertains to my lord, non-payment of my lord, family pension, share of the family pension to that daughter, my lord.
daughter of the second wife.
Second wife, my lord. The second wife filed approach before this honorable because my lord, the daughter is minor, my lord. He represented the my lord, her daughter, my lord. And
All the parties are represented.
all the parties
Yes.
represent my lord.
Who's for respondent 8?
My lord, I am appearing for respondent.
First wife.
You are the first wife.
First wife.
Oh.
And my lord, recently, my lord, the Assam pension rule amended, my lord. My lord, it is hereby, my lord, permissible for sharing, my lord. Amendment of 143. 2. The principal rules, the rule 143 in sub rule, clause C in the proviso, and Roman C note 2 after clause C, the following new clause D shall be inserted. If the family pension recipient does not divide the amount among the other beneficiaries in equal share, and on receipt of such complaint from the eligible family members, the competent authority shall issue orders apportioning the family pension among other eligible family members. In Supreme Court, Rameshwari Devi,
So any dispute that where is the birth certificate?
Birth certificate, my lord, find it, my lord. And next of kin certificate, my lord, see page 17, my lord. Original page 18. MS Bhargavi Mohanto, daughter, 8 years, in the year 2014.
Okay. This is not under challenge.
This is not under.
So let the matter be disposed of in terms of the orders of the court.
It can be disposed of.
Ah.
There is no issue. But one small issue is that so far as the note is concerned and the pension rule is concerned,
The dispute would have arisen had I not shared the family pension with the second wife's daughter. I have not been receiving any pension since 2012.
We'll direct them now.
There is no, and they have issued a pension paper order, but that has been stayed by this honorable court by an interim order.
We'll dispose it of, vacate the interim order. Heard, learned counsel for the parties. Disposed, interim order dated 22 stands disposed. The authorities will pass a detailed order. You will pass necessary orders, pension, which is the department? Agriculture.
Department.
So, your proposal has been sent.
My lord, here during the pendency of this writ petition, we received the proposal and we authorized the family pension in respect of the first wife. Since there is a my lord interim order, so we immediately returned to the treasury officer and as on date it has been stopped, my lord.
Who is to be directed to release it to the daughter? I mean, sorry.
The first wife.
You'll have to be. It will have to be shared by respondent 8.
Yes, well, well, it will
Not as if, because my lord, yes.
Not by AG. Not by AG.
Because we have the PPF
Pension
cannot
will be given to respondent 8.
Yes.
You will have to share it.
yes.
In
And there
case
is
of
a
any grievance, you raise it before the authorities. Authorities are within their powers to stop the pension in terms of the amendment of the rules.
and
on receipt of any complaint from the my lord, petitioner, that can be divided by the authority, my lord.
and there is a clause C, the signing of indemnity bond.
Indemnity bond.
My lord, in every case,
Hmm.
it will come in the amended after note 2.
Hmm.
Note 2C in the Assam Service Pension Rules 1969. It says in every case, the family pension recipient has to sign and submit an indemnity bond to the competent authority so that the recipient divides the amount amongst the beneficiaries in equal share.
What is the daughter also a party? No.
No, my
No,
lord.
my lord.
Because she is a minor, my lord. At the time of filing, my lord. Now 18 years, my lord.
And as per the full bench judgment passed by this honorable court, if there is any dispute and if the daughters or the beneficiary are not maintained properly, they can raise the issue before appropriate forum. This is what the law laid down by the full bench.
Okay.
I am relying upon the Rameshwari Devi, my lord.
Okay. Following Rameshwari Devi, I think there are judgments of this court also for children.
The
Okay.
full bench judgment also may be
Yes,
taken note of.
we'll look into it. Dispose. Dispose.
Much obliged.
Yes.
Lordship may kindly peruse the order dated 5/10/23. By which order the service record of the husband of the petitioner to be obtained also. And that I have received, Lordship.
Hmm?
Service record of the petitioner, this is I have received, Lordship. Husband of the petitioner. That is I have received, Lordship. And otherwise, in telephonic instructions, there are two claimants, Lordship, the mother and the wife.
We'll go as per the rules,
Yes, Lord.
as per the rules.
I'll get the instructions shortly, Lordship.
All right. MSD Bora Learned Council, Standing Council, Health Department, prays for further time to complete her instructions. Mr.
Yes, Rana.
S. Rana, Learned Council, appears for the writ petitioner, who does not object to the prayer made, matter be listed after 3 weeks
Lord,
to enabling the respondents to complete their instructions.
God bless you.
Yes, correction done.
Yes, it's done, Lordship, and we have got a copy of that.
All right.
And I'm so
MSS
extremely sorry I wasn't here on call the other day before yesterday.
MSS Chakraborty, Learned Council for the petitioner, Mr. P. Soikia, who is appearing? MSA Chakraborty.
Is there.
Appearance for the pension department. It is submitted by the council to the bar that the correction prayed for by the writ petitioner has been carried out by the department. A correction prayed for by the petitioner in respect of the name of the spouse.
Yes.
The writ petitioner.
Copy
In the
of which has been served on.
in the PPO.
Yes.
And copy thereof having been served on the writ petitioner, no further cause survives. The writ petition is accordingly dismissed as writ petitioner is
Disposed.
accordingly closed as disposed of. The interim orders, if any, stands marged.
Deeply applied.
ಇದು ಐತೇನೆ ಕ್ಯಾನ್ Scan copy is not come.
Not received, my lord. The last occasion, Lordship was pleased to call for a skin copy, my lord.
Only push all of others already released on bail.
Let me call for the let it wait for a short
My
while.
But, Sir is already found by. On 26/10/23.
We'll try on 7th.
Right.
7th March.
My lord, obliged.
Yes. What is this? Why is it for order?
May I please, your lordship? My lord, as per the Lozima Court's order, my lord, dated 14/2/2023, my lord, service is deemed to be completed upon the private respondent.
But none appears. Anyone appears?
My lord, none appears, my lord. My lord, matter is very limited, my lord, regarding non-payment of arrear salary, my lord.
That's all right. Service is deemed to be complete.
My lord, my lord.
So let us give them one more chance. to
Yes,
appear.
yes, my lord.
As per Lozima Court, as per office note, Lozima Court has held that service is complete in respect of respondent number 4. However, none appears for respondent number 4. Let the matter be listed again on 11th. Mr. A.R. Bhuya appears for the petitioner and the attorney for the state. 11.
Obliged.
Yes.
As per the Lozima Court's order dated 19/2/2024, the service of notice upon the respondent number 6, my lord, is deemed to be served. And one, my lord, I have checked up the record. The respondent number 6 has sent the Parawas comment to the directly to the court, my lord. My lord,
Who is respondent 6?
respondent is a head superintendent, head teacher of
Headmaster.
headmaster.
As per Lozima, as per office note, service on respondent number 6 has been completed. However, none appears for respondent 6. Then the matter is called up. List again on 11th March. Mr. R. Islam for the petitioner, Mr. N.J. Katonier for the respondent education department. Yes,
That's all, well, but his affidavit is required, but he sent the.
we'll decide. Once notice is served, it is up to them to appear,
Yes.
not appear. We are giving them one opportunity to
Yes.
appear on 11th.
Directly sent to the court. Well. Obligation.
Lordship, the engaged counsel is in lags in another court.
Not
So
a
we
ground
pass-
for adjournment.
Okay, okay, Lord.
You argue?
I'm petitioner from behalf of SP Sharma. Sir.
Hmm. Office note dated 2002-24 reflects that service on respondent number 5 is complete. However, when the matter is called today, none appears for respondent 5. Mr. So-and-so appears for petitioner and Mr. Talukdar for the respondents. List after 2 weeks.
Thank you.
Mr. Karonier also.
Hello, in this case, PDPD in opposition file on yesterday, so I shall file reply. So 2 weeks time may be granted.
Mr. R.M. Chaudhary, learned counsel for the petitioner, submits that he like to file reply affidavit to the affidavit in opposition filed with the respondents. M.S. Lala appears for the CGCA account Assam Rifles.
Lordship, on behalf of P. Chakravarti.
Of P. Chakravarti. Matter be listed. Tell us when you want.
2 weeks time.
2 weeks. Be listed after 2 weeks, enabling the petitioners to file reply affidavit.
It may be fixed.
Date. You'll be able to file within 2 weeks.
I'll not after 2 weeks.
All right, 18th March. 18 March. Where is the petitioner? You have released.
Well, order has been passed, but I think it's not disbursed, my lord. It will be disbursed by, because the CO sign is pending, my lord.
Okay, our instruction is that till yesterday night we have not received any.
He says it has not been disbursed.
Not yet disbursed, my lord. Order has been passed, my lord, for release of.
When likely?
I'm been told the once the CEO signs the check, my lord, it will be disbursed. Maybe kept on
No, CO sign
today.
today is likely to get. What is the amount that you are praying for? This is the entire amount.
No, Your Lordship.
Then
This amount, my lord, in our affidavit, we have stated that this is the amount which is likely to be.
heard learned counsel for the parties, Mr. P.K. Munir, learned counsel appearing for the Assam Khadi and Village Industries Board submits that the amount of 676,110
110.
is ready for payment to the petitioner. The same is likely to be disbursed within a period of within a day or two. He, Mr. So-and-so learned counsel. Your name?
R. Borology. R. Borology.
R. Boro.
Boro.
Learned counsel appears for the petitioner, submits on instructions that the amount has not yet been released. Accordingly, taking into consideration the submissions made by the respondent counsel, taking into consideration the submissions made by the respondent counsel, let the matter be listed again
On 29, Your Lordship.
29th
Lordship.
of 29th of March.
No, Your Lordship.
This 29th.
This 29.
This 29th is not possible. We can give you some date on 13, 14. Huh?
13.
Be listed again on after 2 weeks.
13.
Enabling the, let it be after 2 weeks. You get it, you make a mention if required. After 2 weeks.
Obliged, Your Lordship. Deeply obliged.
Yes.
Dear Lordship, may I kindly come to page 69, running page 69. Annexer L. That is the type copy, my lord.
Yes.
1993 rules. But what are exactly the rules all about? The first paragraph, in exercise of the power conferred by provision to Article 309 Constitution of India, the Governor of Assam is pleased to make the following rules regulating the recruitment and conditions of service of the person appointed in Assam Treasury Establishment Services. So these rules, my lord, are promulgated under the provisions of my lord Article 309, with particular, my lord, reference to, my lord, the recruitment and conditions of service. Then, Lordship may kindly mark that, my lord. The object, my lord, object and purpose of these rules. Then, Lordship may
Where
kindly.
is the object?
The object as such is not, my lord, given here, my lord. But this is the
Reading from Rule 11.
No, Rule 11 is quoted. Before that, my lord, in exercise.
Okay. Recital.
Recital, yes, my lord. In exercise of the powers conferred under provision. That Lordship may kindly mark it. Same thing is also available at page 71 also, but this is the type copy. Then Lordship may kindly come to page 72, running page 72.
Yes.
My lord, Rule 5, Sub-Rule 1. This is opening, my lord. At the very first instance, my lord. On top of the page, Lordship will get it. Method of recruitment.
70?
72.
72.
Yes, running page 72.
Yes.
The upper portion is little illegible, my lord. Ineligible, but in between, Lordship will find Rule 5, method of recruitment. Then Sub-Rule 1, promotion. Lordship got it, my lord. Promotion to the cadres of superintendent, accountant, and senior accounts assistant shall be made as per the recommendation of the selection board constituted under Rule 14 only. So this is how, my lord, the mode has been prescribed by way of which, my lord, the promotional exercise is to be carried out. For the purpose of, my lord, promotion to the post of senior accounts assistant, amongst other posts. Here we are concerned with, my lord, the post of senior accounts assistant. Now, my lord, in the affidavit, my lord, filed by the treasury officer, Lordship may kindly take up that affidavit, my lord, filed by the respondent number 3. Affidavit in opposition. Only one affidavit has been filed, my lord, on behalf of all the respondents. Their lordship may kindly come to page 25. That is a part of the, my lord, minutes of the selection board. Selection board meeting, my lord, held on 10/10/2014.
Yes.
Page 25, resolution number 3.
Yes.
Select
Why did you point out to the rules?
the rules, my lord, how to interpret, because I will be harping on the interpretation of the word and. The conditions of service is there. Now, if a person is required to be promoted, whether, my lord, the literal and ordinary meaning has to be imported, or we can, my lord, take, my lord, the aid of any, my lord, external, my lord, rule of interpretation.
Okay.
Only to, my lord, convince, my lord, to that extent. Because these are the rules, my lord, governing the service conditions and recruitment.
Yes.
Before that, lordship will kindly see the decision-making process. Resolution number 3, selection of senior accounts assistant. All posts of senior accounts assistants will become vacant at Kamrup Treasury establishment on promotion of equal numbers of senior accounts assistant to the post of accountants. One at so and so, so and so. Then the second subparagraph, as per provision of Rule 11(2)(c), this lordship has already seen, my lord, of the Assam Treasury so 93 as amended up to date, a junior accounts assistant who has completed at least 5 years of service as junior accounts assistant on the first day of January of the year of promotion and has successfully undergone the training and passed the departmental examination as may be prescribed under Rule 18 shall be eligible for promotion to the cadre of senior accounts assistant. Now, my lord, lordship was, my lord, putting a query whether these words, my lord, and appearing in this rule would be, my lord, disjunctive or, my lord, conjunctive. Whether these conditions appearing in rule, my lord, 11(2)(c) can be read, my lord, independently to each other or, my lord, in continuation.
It is not. It is not the word and. It is at the as on 1/1, as on 1st January.
As on 1st January.
Whether
and,
no.
Yes.
The emphasis is not on the word and
or.
Emphasis, the interpretation which will be necessary is with regard to how to apply the 1st of January. Does it operate only for the experience part or it operates for both?
Yes. Now that can be called out, my lord, if we, my lord, read the Rule 11(c) as a whole, because it is a continuation. Therefore, my lord, lordship was putting the query, my lord, that whether rule that word and
No,
because
we are putting a query because on the plain reading it doesn't appear to be applicable to both.
Applicable to both.
No, it does not appear from a plain reading.
Plain reading.
But as your condition, your submission is that
because all the 3 conditions have to be fulfilled as spelled out in Rule 11.
Where is Rule 11?
Rule 11 that, my lord, will find. My lord, page 4 of that affidavit itself.
Yes, it is here. Page 74, 75.
Yes.
74. Yes.
74, it is also there, my lord. Now, that type copy has been, my lord, laid out at page 69, running page 69. Type copy. 69.
Yes.
Their lordship will come down, my lord, to C, clause C. A junior accounts assistant
Yes.
Yes. A junior accounts assistant who has completed 5 years of service as junior accounts assistant on the first day of January of the year of promotion. My lord, we stop here. This is one part. Second, and has successfully undergone the training and passed the departmental examination.
What does Rule 18 prescribe? Let us see.
It is 78, madam.
Yes, madam. Page 17. It is with regard to training. I am reading it, my lord. A member of the service, Rule 18, a member of the service in the cadre of junior accounts assistant shall be required to undergo such training and pass such departmental examination as the government may prescribe from time to time. The syllabus for training and the departmental examination as on the date of commencement of these rules shall be furnished at Schedule 3. Now, coming back again, my lord, to page 69. Lordship will kindly see a junior accounts assistant who has completed 5 years of and has successfully undergone training and passed the departmental examination as may be prescribed under Rule 18 shall be eligible for promotion to the cadre of senior accounts assistant. Now, sub-rule C consists of two parts. My lord, the first part deals with, my lord, the period of service, the length of experience. One has to complete, my lord, 5 years of service at least, my lord, on the first day of January of the year of promotion. In the present case in hand, my lord, the year of promotion was 2014. This is the admitted position. And in the affidavit, we have stated, my lord, that the petitioner has not passed the departmental examination on the first day of January of 2014. That is the year of promotion. Rather,
This is, what has happened in the minutes is clear.
Yes.
We are trying to understand whether the interpretation given by the selection committee is an interpretation that can be attributed to Rule 11C.
Now, they have.
Now, on that basis, on that point, you give your submission, whatever is there.
Yes, for that lordship will again maybe please to come to my lord, the affidavit filed by respondent be at page 25. These are the part of the minutes of meeting, my lord.
Page?
Page 25 of the affidavit in opposition filed by respondent number 3, my lord.
Yes.
Their lordship will kindly be pleased to come to page 25.
Yes.
I was just reading it, my lord, a part of it, my. As per, my lord, resolution number 3, first paragraph, my lord, I have read it, my lord. The second paragraph, as per provision of Rule 11(2)(c) of the so-and-so, as amended, so-and-so undergone training shall be. The following candidates fall under the zone of consideration. In that table, lordship will find the name of petitioner, that is Bipul Bora, at serial number 4. Lordship will kindly mark that, my lord. Serial number 4.
Yes.
And he belongs to the category of OBC. And on the date of, my lord, consideration of promotion, my lord, he had completed by that time, my lord, a service of, my lord, 5 years, 5 months. On the right-hand column, my lord, lordship will find. And down below, in that same table, my lord, lordship will find at serial number 15 and 16. These are the private respondents out here.
Yes.
At serial number 15, my lord, Kobita Mohanto, she falls under the general category and she has an overall work experience of 23 years, 7 months. 23 years, 7 months. And my lord, the person at my lord serial number 16, Timothy H. Pame, he belongs to Scheduled Tribe Hills category. He has, my lord, overall work experience of 16 years, 4 months as junior accounts assistant. Out of the above junior accounts assistant, serial number 2, 4, so-and-so, and 14 had not passed the departmental examination as on 1st January 2014. Therefore, as per Rule 11C2, read with Rule 12 of Assam Treasury so-and-so, 93, as amended up to date, these junior accounts assistants are not fulfill the eligibility criteria for promotion to the post of senior accounts assistant during 2014. Now, these rules, my lord, which lordship has again seen, my lord, at page 69.
Yeah.
A junior accounts assistant who has completed 5 years of service as junior accounts on the first day of January of the year of promotion. So the first day of January of the year of promotion, at least 5 years of service has to be completed. That is one part. And has successfully undergone the training and passed the departmental examination as may be prescribed. Lordship was putting a query whether the second part in Rule C to the effect that and has successfully undergone the training and passed departmental examination would mean and include, my lord, the first day of January of the year of promotion. Because if we, my lord, interpret the word and appearing in Rule C as a disjunctive, my lord, in the disjunctive connotation, then, my lord, these two conditions for, my lord, promotion would be, my lord, different and independent to each other. I may fulfill one of the conditions and I may not fulfill one of the conditions. Even in that situation, my lord, I am entitled for promotion. Because the second part does not specify and has successfully undergone the training and passed the departmental examination, on which date it is not specified here. That is the difficulty. So therefore, since it is not specified here, we have to read Rule C at one go, as a whole. Meaning thereby that the word and appearing therein, my lord, will have a conjunctive connotation and not a disjunctive connotation. Because the first day of January completed 5 years of service as junior accounts assistant on the first day of January of the year of promotion. There, my lord, first day of January of the year of promotion, it is specified. 5 years, it is specified. Second part, my lord, says, and has successfully undergone the training and passed the departmental examination as well. So when a person is required to pass the departmental examination, that is not spelled out. If it is not spelled out, can we import any other date?
Under what rule is the zone of consideration? What is the rule for consideration of the persons on the zone of consideration? 11C.
C. 11C.
11C.
11C. 11(2)C. This is the admitted
Now,
position.
do you have a copy of the what do you call it?
93 rules. Minutes of meeting.
The agenda for the will be there in the records.
It will be there in the record, but it is also spelled out in the minutes of meeting.
Minutes of meeting.
Yes, yes, which we have spelled out. Yes, lordship then again comes.
Now, no, the reason why I'm asking is if you come to page number 25.
Yes, my lord.
In that minutes,
Yes.
second paragraph.
Yes, my lord.
So, as per rule, so and so, so and so.
Yes.
Following candidates fall under the zone of consideration.
Yes. Following candidates fall under the zone of consideration.
So, the zone of consideration is already decided.
No, they fall under the zone of consideration, but my lord, down below, lordship will see the last paragraph.
No.
Yes.
Either they fall or they don't fall. If they don't fall, their names ought not to have been put up for selection.
Yes.
See, first there are two concentric circles.
Yes.
The first is zone of consideration.
Yes.
Then comes the merit. Then comes the criteria for selection.
Yes.
So while you may be included in zone of consideration, you
Yes.
may not or be selected or fall into the right criteria for selection.
Right.
This is one.
Yes.
But if you don't fall into the zone of consideration, there is no scope for going to the next criteria, next concentric circle.
Lordship is correct.
Now, these are, as per the minutes, these are found to be within the zone of consideration. Who has found them?
Yes. No, my lord, the selection committee.
Yeah, then
Yes. No, selection committee says, my lord, maybe, my lord, it is not as such happily worded.
No, it's not about happily worded.
Right.
Therefore, the agenda to the minutes are necessary. It is the department who will project who are the people falling in the zone of consideration to be placed before the selection committee. Selection committee is not to find out who falls into the zone of consideration. They are to apply the criteria to those candidates
Yes.
who are put up before the selection committee
Yes.
for zone of consideration. That's all.
Yes. So now for that, my lord, query, lordship, maybe please to come to.
Because see, selection committee will not know
Yeah.
who these are put up from the records available with the department.
No, my lord,
Be-
here, my lord, the controlling authority is the deputy commissioner.
Whatever it may be,
Yes.
who is the selection committee here?
Selection committee at page 21, lordship, please
Mhm.
kindly see, of that affidavit itself, my lord.
Correct.
Page
It is the deputy commissioner
Deputy
and all
commissioner,
the other people.
deputy commissioner is the chairman, page 21.
Mr. Counsel,
My
please
lord.
understand the purport of the rules. No doubt, deputy commissioner is the controlling authority. The rules do not give the power to the deputy commissioner to conduct a selection. It gives power to the selection body, of
Yes.
which deputy commissioner is the chairman,
Yes.
and there are other members.
Yes.
So the selection committee is to look into the papers which are placed before the selection committee to find out whether these people who are shown to be within the zone of consideration fit into the criteria for being selected to the post of that particular post. Now the recommendations of the selection committee are ultimately recommendations. It may or may not be acted by the
Yes.
appointing authority.
Absolutely.
So it is not for the selection committee ordinarily
Yes.
to say that they do not fall into the zone of consideration. They are already put up with as candidates who fall into the zone of consideration.
Yes.
If that is the interpretation given to this word, because this is how it is given,
Yes.
following candidates fall within the zone of consideration.
Fall under the zone.
Who has decided that? So if they fall, then it's a question of further deciding whether they actually fall or not fall.
Yes.
You will now have to consider them to be within zone of consideration and apply the criteria
Yes.
for promotion.
Yes, that is what, my lord, is my respectful submission. They have, my lord, at the first instance, my lord, categorize the candidates. This, my lord, will kindly see here, my lord, in the table, they are at the first instance, they are taking up the, my lord, criteria of 5 years.
No, that is an interpretation you are seeking to give to the selection committee minutes.
Minutes.
But these interpretations can be only on 3 possibilities. Number one, the records of your department where the agenda minutes and everything will be reflected. Who decide? Number two, how the rule has been interpreted is obviously not here in the minutes.
Yes.
You are trying.
Yes.
No, it is their interpretation. Whether their interpretation is correct or not is what we are required to see.
Absolutely.
So that will require your submissions as to what is the zone of consideration and what is the role of the selection committee now.
Yes. So therefore, my lord, my respectful submission is that on page 25, my lord, what is clear, my lord, when by saying that the following candidates fall under the zone of consideration, they are applying the yardstick of 5 years. These persons, my lord, total altogether 16 persons, they have already completed, my lord, 5 years of service. As per, my lord, rule 11(2)(c). Then, my lord, at the last paragraph, at the last paragraph at page 25, first they, my lord, first, at the first instance, because the rule is as such, my lord, therefore I am.
Now come to page number, running page 154, I think internally 75. This is rule 12.
Rule 12.
Come to rule 12.
Yes. Rule 12, general procedure of promotion.
Right.
Before, may I read it, my lord?
Yes.
Rule 12, sub-rule 1. Before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each of the cadre. The appointing authority shall then furnish to the board.
Now, hold on.
Yeah.
Who will furnish? Appointing authority.
Now here, appointing authority is the deputy commissioner.
You're coming back to that again. It may be that he is a member of the selection committee, but he is not the selection committee alone.
Yes, yes.
He is not vested on the deputy commissioner.
Yes.
And deputy commissioner himself is not going to say it. It is an office controlled by the deputy commissioner.
Absolutely.
Right. So
Appointing
you
authority
will furnish the following documents.
following the documents and information with
Right.
regard to any as may incumbents in order of seniority equal to 4 times the number of vacancies as are eligible for promotion.
Exactly. Eligible.
Eligible.
Who are eligible? Those who fall into the zone of consideration.
Zone of consideration.
So there is a decision already taken by the appointing authority that they are eligible.
They are eligible.
Now eligibility is as per 11.
11.
You complete 5 years, pass your departmental examination. Now you come.
Yes. Information about the number of vacancies, list of incumbents in order of seniority.
These are not relevant.
Yes.
You come to number 3.
Yes. Character rules and
No, no,
personnel files of the
number 3 of them, not the sub rule 3. 3. Appointing authority shall
yes, madam. The appointing authority shall simultaneously request the board to recommend within 1 month a list of incumbents suitable for promotion in order of preference in respect of each of the cadre in which recruitments are to be made by promotion.
Then come to the next one. 4.
Yes, yes. The selection shall be made on the basis of seniority cum merit in respect of the cadre of superintendent, accountant, and senior accounts assistant. Selection for promotion to the cadre of junior accounts assistant so and so shall be strictly made on merit. Then sub rule, rule 5.
This is what? Senior accountant.
Senior accounts assistant.
Seniority cum merit.
Huh? Seniority cum merit. Yes.
They have adopted a different.
Then comes number 5.
Number 5, the board, after examination of the documents and information furnished by the appointing authority, shall recommend to the appointing authority a list of incumbents about double the probable number of vacancies in order of preference found suitable for promotion, provided that for the purpose of promotion, the zone of consideration by the board shall be confined to 4 times of the number of vacancies.
So the role of the selection committee is only to select on the names which are forwarded. I will ascribe the power that selection committee's power is not restricted only for recommendation. They can also look into the whether they rightly are categorized in the zone of consideration, although not specified. We'll hold that all right. It is permitted. But if we hold that, and if we are to hold that the selection committee found these people not to be correctly assessed in the zone of consideration, then there has to be a proper explanation why.
Yes. Now here, my lord, rule 5 says
4
times, my lord, provided that for the purpose of.
4 times is the final recommendation.
Now
you are supposing you have 3 posts,
Yeah.
then they will recommend 12 numbers.
12. So this has been done. This has been done at page 25. Lordship has seen. In that table, there are 16 numbers of persons.
No, this is the people who are sent to how many vacancies are there?
4.
4 vacancies.
4.
So out of these 4, they were required to submit 12 numbers.
16.
Out of 16, 12.
Out of 16, 12.
12.
12.
As per the rule.
Yes.
They have recommended only 4.
4.
On the ground, all other 3 persons do not satisfy.
Yes.
Meaning thereby, they are even questioning the finding of the appointing authority that these people are included in the zone of consideration. They are disagreeing with the appointing authority.
Yes.
But there is no finding otherwise.
Otherwise. But
what appears to the court is that the selection, if we allow these, the selection committee has gone beyond the powers conferred under the rules.
Yes, my lord. Perhaps, my lord. Because here, my lord,
You look into just above the line, you find following candidates fall under the zone of consideration.
Yes.
Who has decided that?
So,
It must be
Because they have applied the parameters prescribed under
they
the
are
rule.
wrongly applied. That is not their brief.
Yes.
Their brief is to select how
Yes.
many people.
Yes.
But because their selection committee, I will give them that merely because the names are put forward, they will have to accept. No. They will also have the power to find out whether they are in the zone of consideration or not.
My
But
lord.
that is not expressly given.
Now, if
They should have, see, as per the rule, they are to recommend 4 times.
yes,
They could have very well remanded back that according to us, only 4 persons are there.
Yeah.
Rule 12 is not satisfactory. We remand the matters
Yes.
back to the appointing authority
Yes.
for a fresh decision.
now they have already taken, my lord, the final decision.
They have taken a final decision.
Final decision. They have taken the final decision.
But wrongly applying this rule prima facie, unless you say that no, there are law developed by courts to say that this does not indicate questioning the zone of consideration.
That is true, my lord, but
If that is true, then we close it.
I cannot well beyond the records. That is the difficulty. Because
No,
in-
if
in the-
if you go through the rules,
definitely, my lord, now,
as a departmental council, you can only project whatever is available.
Yes.
And your wisdom in terms of interpretation.
Absolutely.
But the rules and the materials are there. So if you think that no, there are some judgments, because this interpretation of and or perhaps is not even required to be gone into at this stage. It's
So
not
how
even
far, my lord, to what extent, my lord, the selection committee can exercise its power?
Can. That's what I said. We will give them the benefit of looking into the correctness of the zone of consideration also. But in which case they'll have to say that as per rule so and so, they are not qualified.
Now,
They have merely
now,
said as per rule 11(2)(c), read with so and so, are not have not fulfilled eligibility criteria
Yeah.
for promotion.
promotion. Now, Rule 12, Lordship has just now seen, my lord. General procedure of promotion.
Hmm.
Now,
General procedure, they are supposed to only recommend.
General, before the date of the appointing authority shall furnish to the board the following information. The number, the information
Anyway,
of the.
you give us some judgments if you have to show that first of the year is a term to be applied to both, namely completion of the
To that
experience.
extent, my lord, of our High Court, my lord, I haven't found any decision, my lord, fairly submitting. But I have, my lord, come up with 2 decisions, my lord. One is with regard to the word and my lord, the second, my lord, the plain rule of interpretation. Because this is what has transpired in the present case. The authorities have applied, my lord, the provisions of rule 11(2)(c) as it is. Because therefore I was initially submitting, because if Lordship comes to page 69,
Yes.
is running page 69, down below Lordship will see rule C typed out. It's your accounts assistant who has completed 5 years of service on the first day of January of the year of promotion and successfully undergone training. Now the second part, has successfully undergone training and passed departmental examination as may be prescribed. That is not qualified with any, my lord, timeline. Although the first part is qualified with a timeline. Timeline is, my lord, that it is the first day of January of the year of promotion.
That again, if you read the rules, it
My
will be clear that departmental examination as held by the department from time to time.
Yes.
Now you will have to say that departmental examinations were held, say, twice or thrice during that time he appeared, he did not clear. Therefore, he cleared after 1st of January on facts.
On facts.
We don't know, it is not here.
Yes. No, my lord, with regard to the others, my lord, with regard to the others, my lord, we have stated that he has not, my lord, the petitioner has passed the departmental examination on, my lord, 16th of September 2014. So it is not on the first day of January of 2014. But the other persons have been found, these two private respondents have been found that they have passed the departmental examination on the first day of January of 2014.
No, I'm saying is
Yes.
whether prior to 2000, uh, first day of January 2014,
My lord.
whether there were examinations held and the petitioner had appeared, he failed to succeed, all these materials will have to.
I have taken specific instruction from my client. No department examination is held.
Because the purpose of 1st of January
My lord.
is only to see the number of years.
Yes.
Otherwise, how else will you calculate?
Yes.
How many years you
Yes,
completed?
yes. That is the baseline, of course.
This is the baseline.
Baseline, yes.
Rest of the criteria prior to the, because there are judgments that prior to the date of, when were these, when was the names put up for selection?
My lord, it is in the year 2013.
13.
Yes.
Is there any judgment you have found out on this interpretation, first day of January?
First day of January, my lord.
I have found not on the cutoff date, my lord, but how it should be interpreted when there is no express provision. My
What does it say?
lord, shall I have given the book, please? My lord? It's a 2008 5 SCC.
You read it?
176. Lordship para 18. Anisini na? Mm, 176. I said? Lordship, I'll read it. My lord.
What is that? 2000?
8 5 SCC 176. Karnataka State Financial Corporation versus N. Narasimha and
Sorry,
others.
page number
176, my lord. I'll be
Paragraph?
relying on para 18, para 40 and 42. And para 29 and 36 also, my lord.
Okay.
Lordship, may I read it slowly, Your Lordship. Para 18. If special provisions are made in derogation to the general right of a citizen, the statute, in our opinion, should receive strict construction. Industrial concern has been defined under the Act. For the purpose of enforcing a liability of an industrial concern, recourse can be taken both under Section 29 and 31 of the Act. Right of the corporation to file a suit or take recourse to the provision contained in Section 32G of the Act also. Then, Your Lordship, para 40. Right to property, although no longer a fundamental right, is still a constitutional right. It is also a human right. In absence of any provision, either expressly or by necessary implication, depriving a person therefrom, the court shall not construe a provision leaning in favor of such deprivation. Here, in the instant case, Your Lordship, since there is no express provision as regards the cutoff date regarding obtaining Lordship, that qualification, my lord, regarding training, part and passing, departmental examination, the Lordship may hold that in absence of that.
We'll hold whatever we want to hold. You tell us what.
Lordship may
what
please,
is your
may I
interpretation?
submit? Lordship, it may go in favor of the accused. I'm sorry, I'm doing criminal cases. It comes into my mind, my lord. In favor of the petitioner, my lord. That
No. That is a general proposition.
My lord.
That whatever interpretation ordinarily should be in favor of the.
My lord,
We are asking you to do a little more. We are
Precise.
requesting you to go a little more beyond.
My lord.
That in the category for examining the criteria for falling into the zone of consideration. How is the criteria to be assessed?
My lord.
Because there will be a lot of judgments in the service
My lord.
sector.
My lord.
Because this is a very standard criteria.
My lord.
Completing so and so days in the first day of so and so departmental examination, etc. Now, the committee has held that you did not clear departmental examination,
My lord.
which according to them is an interpretation that This 1st of January is applicable to both, not only for the experience, but also for department.
Department examination. My
You are trying to submit to the contrary. So is there any proposition you are holding it on the basis of case law?
Case note, I do not have, I would not bring, only on interpretation I have brought, I'm honestly.
You have to ask your junior colleague to
My lord.
spend the weekend.
Yes, my lordship may please to, lordship is correct in holding that even if that point goes, the other point still remains the criteria for promotion. That they have adopted a different as contrary to the rules.
No, but then if you do not fall into the zone of consideration,
My lord.
wrong application of the criteria doesn't affect you. You are not even there in the zone of consideration. You first have to enter into the zone of consideration.
And for rejecting my, since my case was considered for zone of consideration,
No, no.
so it was placed before the department promotion committee. My lord.
That is what we that is what we feel
My lord.
is or that is our understanding on the papers.
My lord.
But we are trying to come up with a finding that whether the interpretation given by the committee is
Correct or not.
goes contrary to the
My lord.
rules. Mr. Borpuzari?
My lord. Here, my lord, lordship has seen, my lord, the minutes of meeting of the selection board, how they have taken up that exercise. They have taken up the exercise, my lord, in twofold. In the first fold, my lord, applying the provisions of Rule 12, my lord, they have, my lord, earmarked, my lord, or cornered, so as to say, my lord, 16 numbers of persons against four vacancies. It will be double. Now, once 16 numbers of persons have been earmarked, my lord.
How?
On the basis of parameters of 5 years. That is the first part of 11(2)(c).
On what basis you are saying it?
Yes, it is in their page 25. The table itself shows. The table shows.
25.
Page 25, my lord, of the affidavit in opposition, my lord. Filed by respondent number 3.
Where?
My lord, in the table, my lord, page 25, lordship will see a table down below. Resolution number 2.
No. Before the table follows the second paragraph. You read the second paragraph?
Yes, my lord. As per provision of Rule 11(2)(c), the Assam Treasury so and so as amended, a junior accounts assistant who has completed 5 years of service as junior accounts assistant on the first day of January of the year of promotion and has successfully undergone the training and passed the departmental examination as may be prescribed shall be eligible for promotion to the cadre of senior accounts assistant.
So,
yes.
Thereafter, you say these fall under the zone of consideration. It means that they have completed both, they have satisfied both criteria.
Yeah, but it does not appear to be so from a reading of these minors. Why I am minor making that submission? Because lordship will see their findings, the findings of the selection board in two parts. The first finding is the table itself. There, my lord will find, my lord, 16 persons against 4 numbers of vacancy. And on the right-hand side column, lordship will see against each of the 16 number of candidates, my lord, the basic parameter is 5 years. All have completed 5 years. Someone has, my lord, completed even 23 years. Some has completed, my lord, 16 years.
No. See, that there again we go back to the question which we asked you.
My lord.
Following candidates fall under the zone of consideration. Who has decided that? Zone of consideration is very clear, 11(2)(c).
Zone of consideration is 11(2)(c). So therefore, my lord, I was making that submission because 11(2)(c), my lord, consists of two parts. First part and the second part. They have, my lord, no, my lord, lordship will kindly bear, my lord.
No. The moment you say they fall under zone of consideration, they must be understood to have completed both.
Therefore, I say that it is not happily worded. My lord, the second paragraph down below, lordship will kindly.
Really unhappily worded, you'll have to say from your records.
Yes, my lord.
From the minute, it is not there.
No,
this will be evident from the agenda put up before the committee. It is the agenda which will reflect how many people satisfy the criteria, how many people don't satisfy the criteria.
It is already there. My lord, let me read, my lord, the last paragraph. Lordship has seen, my lord, the table. The table, my lord, is 16 persons against 4 number of vacancies. Now, in the last paragraph, my lord, at page 25, they say, out of the above junior accounts assistant serial number 2, 4, so and 14 had not passed the departmental examination as on 1st January 2014.
On what basis have they said it? On what basis?
Then, my lord, that record should be required
On what basis?
because they have not challenged this, my lord, minor submitting, I think.
They have not challenged it because they feel that technically the entire selection has to be otherwise interfered with because you have applied the wrong criteria. Merit comes in already.
Yes, because why they have not challenged at a subsequent date, they are now say, my lord, making a claim for my lord seniority with retrospective effect. On an ante date, my lord, he was selected by applying the same parameters. That lordship will find, my lord, at page 35 onwards. Page 35, same parameters.
Subsequently,
Yes.
that is again a wrong parameter.
Nonetheless, my lord, because they are seeking an equitable relief. My lord, the selects, my lord, lordship, I can understand, my lord. Technically, my lord, here and there, my lord, these authorities may be wrong. But one fact, my lord, in my respectful submissions, which still remains, are the provisions of Rule 11(2)(c).
This is what we are asking councils to give us.
Yes, my lord, therefore,
Interpretation.
yes, now, my lord, my interpretation is that, my lord, that this Rule 11.
No. What's interpretation of court?
Yes, I'm there. My lord. Yes. So before that, I will have to satisfy my lord with the regard, because this is my basic submission, that 11(2)(c) has to be read as a whole.
We have
Yes.
noted your submission.
Yes. Accept the first decision. Well, I am giving both, two of the, it would be. It will. I'm relying on two, my lord, FX decisions, my lord. So the first is, my lord, 1992, 4 SCC 711.
Yes.
1992, 4 SCC 711. Their lordship will kindly come, my lord, to paragraph 8. In that particular case, my lord, a person was, my lord, a departmental proceeding was, my lord, drawn up against the person, and parallelly, my lord, criminal proceedings were also drawn up against that person. Now, my lord, in the criminal proceedings, my lord, it had culminated into acquittal. And my lord, the departmental authorities, they came to a finding that, my lord, that no, the departmental proceeding has to be dropped, and again, it has to start afresh. Against, my lord, starting afresh the departmental proceeding, he moved an OABA, my lord, before the tribunal. Finally, matter came to the Supreme Court. My lord, paragraph 8. The language of sub-rule 4 of Rule 10 is absolutely clear and does not permit any artificial rule of interpretation to be applied. It is well established.
So let us take us through rule
Yes.
10(4) first.
Yes, 10(4) lordship will find at paragraph 6. May I read it, my lord?
Yes.
The other question relating to the automatic suspension of the appellant by virtue of Rule 10(4) is a serious one. And in order to appreciate the argument of the appellant, it is necessary to examine both sub-rules 3 and 4 of Rule 10, which are quoted below. Number 3, sub-rule 3, where the penalty of dismissal, removal, or compulsory retirement for service imposed upon a government servant under suspension is set aside in appeal or on review under these rules, and the case is remitted for further inquiry or action, or with any other directions, the order of his suspension shall be deemed to have continued in force on and from the date of the original order of dismissal, removal, or compulsory retirement, and shall remain in force until further orders. Then sub-rule 4 says, my lord, where a penalty of dismissal, removal, or compulsory retirement from service imposed upon a government servant is set aside or declared or rendered void in consequence of or by a decision of a court of law and the disciplinary authority on a consideration of the circumstances of the case decides to hold a further inquiry against him on the allegations on which the penalty of dismissal, removal, or compulsory retirement was originally imposed, the government servant shall be deemed to have been placed under suspension by the appointing authority from the date of the original order of dismissal, removal, or compulsory retirement, and shall continue to remain under suspension until further orders, provided that no such further inquiry shall be ordered unless it is intended to meet a situation where the court has passed an order purely on technical grounds without going into the merits of the case. Then paragraph 7, it has been contended on behalf of the appellant that while in a case governed by sub-rule 3, a government servant on the order of his punishment by way of dismissal, removal, or compulsory retirement from service being set aside stands suspended only if he had been under suspension earlier. Sub-rule 4 provides for automatic suspension of a government servant, even if he was never under suspension at any point of time. And this invidious distinction amounts to illegal discrimination, which renders sub-rule 4 unconstitutional. The argument is that with a view to save the sub-rule, its application has to be limited to cases in which the government servant has been during the pendency of the disciplinary proceeding. The council proceeded to say that the established principle of interpretation favoring reading down of a statutory provision in order to avoid it being struck down as illegal is applicable to this case. If it is found not possible in view of the clear language of sub-rule 4, the same should be struck down as unconstitutional. In either event, it should be further held that the appellant who was not under suspension earlier cannot be treated to have been placed under suspension when his writ petition was allowed by the tribunal. Reliance has been placed on the decision of so-and-so. Now, paragraph 8. The language of sub-rule 4 of rule 10 is absolutely clear and does not permit any artificial rule of interpretation to be applied. It is well established that if the words of a statute are clear and free from any vagueness and are therefore reasonably susceptible to only one meaning, it must be construed by giving effect to that meaning irrespective of consequences. The language of the sub-rule here is precise and unambiguous and therefore has to be understood in the natural and ordinary sense. My lord, my
appears
submission
to be supporting the case of the petitioner more than your. The argument there was, if there is an, under the rules, if the person, if there's a conviction, something which is set aside, he is deemed to be under suspension. The argument made was he is deemed to be under suspension only if he was under suspension.
Yes.
Court holds otherwise, saying that plain reading does not reflect that he has to be under suspension. Plain reading is, if that order is set aside, further inquiry, de novo inquiry is made, he will be placed under suspension or deemed to be under suspension. Now, similar is the case here.
No, my lord, here, my lord, what the apex court has said, my lord, language of is absolutely clear and does not permit any artificial rule of interpretation.
Exactly.
This is
The language of the rule is clear that this beginning of the first of the year is only with regard to completion of the years of experience.
And my lord, with regard to the second part.
That is what I am saying. That is why the interpretation is necessary.
Yes.
Because the rule on the plain reading does not say that beginning of first year is applicable to both. Plain reading.
Plain reading, my lord, yes, because it does not, because it is qualified with the word and. Therefore, my lord, why my it has to
And
be
no. The particular section is with regard to including in a zone or qualification for being included in a zone of consideration. For a zone of consideration, there are two criteria. You complete 5 years as on first of the year of the vacancy.
Yes.
You complete the departmental departmental examination and successfully clear it. Undergo training and departmental examination. Now, plain reading does not reflect that all three must be at the first of the year when the vacancies are required to be filled up. What is there on the first year, you have to complete the number of years.
Now, my lord, with all humility, my lord, I beg to differ, my lord, on the aspect that it is qualified with the words and. It is not qualified with the words or. Had there been a word or, my lord, because this and appears in two places, my lord. Lordship is correct.
No, it can be or, because your 5 years is also mandatory requirement.
Yes, so therefore, my lord, 5 years plus departmental examination, which the my lord selection board has found, my lord, taking into account the twofold requirement of, my lord, for being promoted. One has to complete 5 years and one has to also, my lord, pass departmental examination on the first day of January of the year of promotion. Now here, because the second part, that was, my lord, that is what, my lord, I am harping again and again, because the second part, and has successfully undergone the training and passed departmental examination. This is not qualified with any timeline. And the word used are and. The timeline is fixed, my lord, is spelled out only at the initial, my lord, at the very beginning of this, my lord, sub-role. At the very beginning of the sub-role, a junior accounts assistant who has completed 5 years of service on the first day of January of the year of promotion. It is only there, my lord, that the first day of January has been clearly spelled out. And in the later part of that rule, my lord, the first day of January of the year of promotion, that is not again repeated, either repeated nor spelled out, my lord. So therefore, my lord, it has to be naturally construed. By my lord, dint of the use of word and. Therefore, my lord, it is my respectful submission, my lord, that one has to complete 5 years at the same time, my lord, one also has to, my lord.
Then why were they put up? They ought not to have been put up for selection committee.
No, because of the, my lord, requirement under rule 12, my lord. Because rule 12 says, my lord, four times of the.
That is after selection.
After selection.
Before selection, you have to find out who are eligible to be selected.
Yes. Therefore, my lord.
Why were they put up if they did not?
Yes.
If that is the interpretation.
That is correct, my lord. That is on record. It is there, my lord. I cannot, my lord, improve the. It is there
Yes.
already. But at the same time, lordship will also, my lord, kindly lord, it is on the same.
There is another judgment you have.
Yes. Another judgment, my lord. The second, my lord, is 2002 SCC 62. There, my lord, the Supreme Court has, my lord, interpreted the word and. There, lordship may kindly come to, my lord, paragraph 6, 7, and 8. That was with regard to, my lord, publication of notification in the event, my lord, an election petition is sought to be withdrawn. Lordship may kindly come to paragraph 6. May I read it, my lord?
Yes.
It is, my lord, with regard to the, my lord, Representation of People Act, 1951. Paragraph 6. Section 110 of the Act provides, 110 provides procedure for withdrawal of election petitions. If there are more petitioners than one, no application to withdraw an election petition shall be made except with the consent of all the petitioners. Number 2, no application for withdrawal shall be granted if, in the opinion of the High Court, such application has been induced by any bargain or consideration which ought not to be allowed. Then number 3, if the application is granted, the petitioner shall be ordered to pay the cost of the respondents and therefore incurred on such portion thereof as the High Court may think fit. B, this is important here, Mala, this is what has been interpreted. The High Court shall direct that the notice of withdrawal shall be published in the official gazette and in such other manner as may be as it may specify, and thereupon the notice shall be published accordingly. Then, my lord, paragraph 7. A bare perusal of section 110(3)(b) shows that the High Court shall direct the notice of withdrawal of the election petition to be published in the official gazette and in such manner as it may specify. Clause 3 of section 3 provides that within 14 days of such publication, a person who might himself have been a petitioner may apply to be substituted as a petitioner in place of the party withdrawing the election petition, and upon compliance with such conditions as may be imposed by the High Court, he may be permitted to continue the proceedings. Now, paragraph 8, my lord. Clause B thus unmistakably suggests that it is a mandatory requirement that the High Court shall cause the notice of withdrawal to be published in the official gazette. Apart from publication of the notice in the official gazette, the notice may also be published in such other manner as the High Court may specify. The expression in the official gazette and in such other manner as it may specify, emphasis supplied by us, clearly suggests that the publication in the newspaper or in any other manner is in addition to the publication of the notice in the official gazette and not in substitution of it. If the date of publication in any other manner precedes the date of publication in the official gazette, the period of 14 days prescribed in clause C within which a person may apply to be substituted in place of the original election petitioner would ordinarily not commence unless publication in the official gazette has also taken place in the present case. So therefore, my lord, the cue, my lord, that I am taking up, my lord, from a bare reading of paragraph 8 is that, my lord, the use of word and is, my lord, in addition, my lord, these are, my lord, additionals. It cannot be substituted. The requirement of 5 years cannot be substituted, my lord, with, my lord, the requirement of passing a departmental examination on the first day of January 2014 of the year of promotion. Or the requirement, my lord, of obtaining a training also cannot be substituted. This is my respectful submission. And so obliged.
Lordship, since the name were placed before the DPC, your lordship, the DPC should not have gone beyond, because it's not their case. The ACS, there are some bad remarks or something. The proceeding is pending against them. Nothing as such, my lord. Only the criteria for rejection is they did not pass the departmental examination. Since the government has lordship forwarded the name of the petitioner along with other incumbents, because they have fulfilled the eligibility criteria of 5 years, passing departmental examination and undergraduate training. And as such, their names were placed before the Department Promotion Committee. But your lordship, in Mayor, because the committee has gone beyond and rejected your case, and on the ground that they did not fulfill the criteria of passing the examination. That's wrong on their part, your lordship. And on that point, your lordship, the case, the selection of the private respondents would go, your lordship. And since they belong to other district and on their own transfer, they have been posted in Kamrup, my lord. They should have placed before, down below the gradation list. But in the instant case, they were placed above the present petitioner. Lordship, that is my respectful submission. And for that reason, your lordship, may please to allow my petition. You've done appropriate relief.
You said you are relying on some judgments subject to.
Lordship, regarding the interpretation of N and or, it's clear, your lordship, because in the second part, the rule doesn't say. As on 1st of January, one has to pass the departmental examination. So that part I may not have to go, your lordship. My respectful submission is there. And your lordship, other criteria I think I have fulfilled, and I'd be relying on the interpretation of statute, how lordship is aware of that, my lord. Page 530 of GP6 statutory interpretation, my lord.
These interpretations are on the basis of case laws.
My lord.
You should produce the case laws.
No, case laws I had produced, my lord. Lordship, in order when the express provision of the statute is silent, court may grant relief in favor of the.
These are relied on by whom? By you?
Which one? Karnataka?
Karnataka?
Yes, my lord, I have relied on. 2008 5 SC 176. 1829-36.
For what proposition?
Regarding how the court should interpret in absence of statutory provision, express provision, my lord.
Paragraph?
Paragraph 18, 29, 36.
1 minute, 1 minute. 18,
29, 36, 40 and 42.
and the other?
And the other one, GPC statutory interpretation, I'm just
No,
relying.
no, 98, 7 SCC?
Oh, 98, 7 SCC, 59, my lord. Not clear. Para 13 and 14, my lord.
1, 3.
Yes, may not be necessary because it's interpretation of N and or, my lord.
Yes. What is your submission?
Before she makes, but only one aspect of the matter. In the affidavit in opposition, my lord, filed by the treasury officer, their lordship will kindly see, my lord, page 35. At a subsequent date, my lord, the petitioner was promoted to the post. In the year 2014, he was not promoted, but in the very next year, 2015, he was promoted by the departmental, my lord, committee, by the selection committee, applying the same parameters, applying the
No, I'm
same.
not, I overlooked that. I'm sorry, my lord. The criteria, wrong criteria has been followed in my case also. I have overlooked that. I'm sorry, my lord. But regarding the other part, I'm still submitting, my lord. There's a wrong on their part in rejecting my case while granting relief to the private respondents. So, your lordship, my respectful submission is that the private respondents be placed below me. I have no objection, my lord. And my name should be kept above the, in the seniority list above the private respondents because they belong to other districts, my lord. And on their own request, they have been transferred to Kamrup Metro, my lord, Kamrup Treasury.
Let us say we allow your petition.
My lord.
What direction do you want?
Lordship to place me above the private respondents in the gradation list, my lord.
On the basis, on a selection which is made by applying the wrong criteria.
No, my lord, because if my case would have been considered on the date when.
You are now asking for notional benefit.
My lord.
You have also been promoted.
Lordship.
Where admittedly the same wrong criteria has been used.
Lordship, if the lordship leaves apart that criteria.
No, how do we leave apart?
Yes, my lord.
You are, nobody is questioning your selection now.
My
on the
lordship,
basis,
that is the thing, your lordship, we kindly take into account. They have not questioned.
They have not questioned.
Yes.
But does it give you, what is your locus to ask for a benefit on a selection where no criteria is, the wrong criteria is, you're a beneficiary of some wrong committed by the department.
No, your lordship, but while rejecting my case, they have taken that plea that I did not qualify. The lordship will, if the lord keeps apart the criteria,
No.
the other thing will remain.
See, had you not been selected,
My lord.
maybe this could have been a case to remand the matter back for a, what do you call, review DPC to consider the case and give you whatever benefits. But you have been selected.
Subsequently.
Promoted. You and the private respondents today are in the same post, isn't it?
Lordship, but while
Only
preparing.
dispute is the seniority.
Seniority.
Now, the seniority benefit you are asking in a post where you have also been promoted by consideration of the wrong criteria.
Lordship, if your lordship keeps apart, let us forget two aspects. That I have not passed departmental examination, the criteria, that the wrong criteria has been adopted. But it's an admitted position, my lord. They belong to other districts. And they have, on their application, they have come to Kamrup Metro Treasury, my lord. So, at a face to face, my lord.
I understand everything.
My lord.
But the only benefit you are asking for is notional benefit today.
Lordship.
You are not asking for promotion now.
Now I'm not asking for promotion. Lordship, because the lordship, we kindly have a look at the draft gradation list now they have prepared. In the year 2022.
We are asking you a question for you to think and tell us.
My lord.
You are coming to the court of equity.
My lord.
Asking for a benefit.
Yes.
In a post where admittedly you have also been wrongly selected.
I understand, my lord.
Notwithstanding.
I was not aware of it because during the pendency, after the pendency of the writ petition, they have considered my case, my lord, after filing of the writ petition, my lord. Not during before that, my lord. But now, your lordship, they have again placed a private respondent at page 86, my lord, of the rejoinder affidavit. Your lordship may kindly have a look at
Yes.
page 86. Kobita Mohanto, serial number 15. Then H. Pame, 16. My name is serial number 17, my lord, page 86.
Where is that notification you pointed out with regard to own request transfer?
Oh, lordship, I have annexed this one, my lord. The application, my lord. A notification, my lord, is yes, yes. Page 34 of the writ petition, my lord.
34.
Page 35. Amendment of Rule 24.
35.
A member ordinarily may be temporarily transferred from treasury establishment of one district to treasury establishment of another district for a maximum period of 5 years unless the member submit his written option as to which treasury establishment she wants to continue permanently for the purpose of promotion, seniority, and confirmation within 1 month of joining the new establishment, which shall be final. All earlier similarly situated employees may avail the option facility within 1 month of the issue of this order. His position shall be at the bottom of the gradation list of new treasury establishment. My lord, at the face of it, my lord, I have annexed the application, my lord, of their own request transfer, my lord. Annexure D, page 30 and 31, my lord. Oh, lordship, page 32 to 33. Annexure E and F.
Yes. Yes.
Lordship, page 32 is a transfer order.
Where is the application?
Lordship.
Application? Is there any application?
Application, my lord. Lordship, page 36 to 44. Page 36. With reference to the subject cited above, I would like to
And where is the order?
order of transfer, my lord.
32.
Page 32. It's a order of Kobita Mohanto, my lord. And Miss H. Pame's application is at page 38, my lord.
Yes. Okay.
Lordship.
Yes.
May it please your lordship, I've submitted a short synopsis of my arguments, your lordship. Lordship, I would like to take you back to Rule 12, your lordship, regarding this issue of whether the cutoff date is applicable or not for undergoing training and passing the examination, your lordship. Lordship, Rule 12.1 states that before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled by promotion in the next year in each cadre. As such, your lordship, for the vacancies in the year 2014, the estimates will be done in the year 2013. Similarly, your lordship, Rule 12.2, your lordship, the appointing authority shall then furnish to the board the following documents and information with regard to as many incumbents.
That we have already gone into.
Yes, your lord.
Point out something that we have missed out or you have.
What I'm trying to say is this estimation has to be done in 2013
That
for
is
the
what
year
we
of
that is
promotion
what
in
we
14.
pointed out in
Yes,
the my notes. They have laid down a list showing that these are the persons
Yes,
which
your
fall under the zone of consideration. That is what the estimation is all about.
Therefore, your lordship, since the petitioner was not qualified
There you
regarding
go
the
again.
examination.
Once you say the estimation has to be done earlier, It is done. Therefore, at page, that second page of the minutes, you find the chart.
Yes.
And the indication, the sentence just above the table indicates that they fall under the zone of consideration. Falling into the zone of consideration is an exercise for doing that assessment. So once that assessment is there done and they're put up, how do you now say that they're not qualified? Number two, the criteria adopted again in your promotion is the wrong criteria as per the rules.
Yes, sir.
Then why should you be given the benefit?
Lordship, in the sense that they did not have the qualification regarding the examination in December 2000.
That is your interpretation,
Yes, sir.
madam. Unless you want to show us that this interpretation is correct from the rules or from some judgments or merely submitting repeatedly that this is the criteria, it does not help. We are going by the departments. The department's understanding is that these people are eligible for promotion, therefore their names are put up. If they did not complete, why were their names put up? For what purpose? It is your submission that the assessment has to be made.
Yes.
Criteria has to be fixed up. If they don't fall under the criteria, why were their names put up? Who put up these names? Department. So the department understands the rule in the same manner as we'd like to interpret. Secondly, there's a wrong criteria adopted. Seniority come merit, and you are enjoying on merit come seniority. Was there an amendment prior to the selection?
No, Your
Then secondly, it is your own transfer. You sought for an own transfer.
Yes, Your Lord. Regarding that seniority, Your Lordship, before that, Your Lordship, I would like to place the definition of word and as per the Black's Law Dictionary also regarding and, Your Lord.
We don't want, we have Black's Law, Webster's, Oxford, whatever we want. We want you to tell us whether any court of law has in a similar parameteria provision interpreted, which you can rely on and which will help us to arrive at a finding. These in the definitions which you have given us in Black's Law and all are available. We have seen it, including interpretation of statutes. It is there. We want to know because this is a standard criteria used in all service matters, all service rules, if you look across in the state and center. So there must be judgments. But somebody will have to make an attempt to find out. If you have that, please, for us.
Lordship, I don't have any judgments as of now, but I would just like to make a small submission that if the word and is interpreted in any other way.
Basis?
Yes, sir.
What is the basis of the submission? Is it your understanding? See, the interpretation which you give us has to have some basis.
Yes.
Maybe with the reference to a definition, maybe with a particular circular notification or judgments, or even a treatise by a famous author who has determined in a similar provision how it is to be interpreted. How else will you interpret? It is a question of your interpretation versus petitioner's interpretation. How do you decide which is the correct interpretation? It is tilting slightly in favor of the petitioners because of the department forwarding them within the zone of consideration. For you to get the tilt back in your favor, you have to rely on some authorities to tell us. What authorities other than Blacks?
Lordship, even the interpretation of statutes, Your Lordship, as per GP Singh, Your Lordship, I don't have any judgments as of now, Your Lordship.
You have to. You don't have because you have not attempted to find out. There are. You find out down the weekend. We'll give you an opportunity for final hearing on Tuesday again. Yes?
And Lordship, another submission, Lordship, regarding the claim of restoration of seniority, Your Lordship. Since the petitioner was promoted in 2015, it is but obvious that we have been promoted in 14, so our name is above in the new gradation list of 2022, Your Lordship. And regarding the transfer in terms of Rule 24.
No, see, at the cost of displeasing you, let me tell you, you are not going to like it, what I'm going to tell you, but let me tell you, the submissions and conversations are different. You are appearing in a court as a counsel. Your submission must be on the basis of facts and the law. What you wish, what you feel is not relevant for us. So whatever you just said is what you feel. You're ventilating what your clients have said. But as a counsel, as an officer of the court, tell us on the basis of the facts, on the basis of the law, on the basis of the rule, why their claim is not maintainable. Tell us, we'll listen to you.
Regarding the claim of seniority, Your Lordship.
Yes.
Lordship, they are claiming that in terms of Rule 24(2), because there's a transfer, that's why they should be placed below. However, Lordship, we have been given an option for enlistment, Your Lordship, which is there in our affidavit in opposition, dated 15/10/2011.
Enlistment has come later.
Yes,
Your transfer
was in 2003.
Ah.
Thereafter, the enlistment, Your Lordship, and thereafter, our names appear below them, Your Lordship, in 20 and 21.
Then
Therefore, we are already below. But in the next cadre, in the senior accounts assistant cadre, we have been promoted in 14. That's why we are above them, Your
that is their case, that they ought to have been promoted. They will have been above you. That is their case. How are you justifying this argument? It is their case that they have been left out. You ought to have been promoted. That is their case, which is why they are asking for notional benefits to rectify the seniority list and to be placed above you. Yes, we close it.
Fine.
Or you don't want any further opportunity?
Lordship, if I will submit a few decisions by Monday or Tuesday, Your Lordship, regarding the interpretation then, Your Lordship.
All right, Tuesday. But largely the arguments are heard.
Yes,
We may dispose it off on Tuesday or Wednesday, but let it be listed on Tuesday. Tuesday. Yes. Wednesday. Wednesday. Thank you.
Obliged, my lord.
Obliged.